Item for 1 and 2 Pugma bench.
For reasons recorded in the judgment, both the criminal petition, that is criminal petition number 5 and criminal petition number 27, are dismissed. However, for the reasons discussed in the foregoing paragraphs of the judgment, learned session judge cum special judge Kohima would be well within his powers to take cognizance against other 2 accused persons, namely Rahul Kharel and Deepak Lama, on the basis of incriminating materials against both of them in the charge sheet.
Item 3.
3 is also dismissed for the reasons mentioned in the judgment.
Item number 1.
For reasons mentioned in the judgment, the impugned judgment of the special judge is hereby set aside, and the appellant is acquitted of charges under section 21C of the NDPS Act. He shall be released forthwith if not wanted in connection with any other case.
Please, Your Lordship. I beg to item number 28 and 30 out of same FIR, Lordship. So a scan copy has not been received, Lordship, till today. It's from Kamrup Metro, Lordship. Can it be next week on 16, Lordship?
28 and
28 and 30.
28 and 30.
They are appearing.
Okay. Heard Miss S.K. Nargis, learned counsel for the petitioner. Also heard Miss M. Deka, learned counsel appearing for NCB. It appears that the scanned copy of the case record, which was called for in connection with this case, has not yet arrived. Issue reminder, registry to issue reminder for the scanned copy of the case record. Let the matter be listed again on 16th of
16th September.
16th of September.
Deeply obliged. Highly obliged.
May I please, Your Lordship? I beg to mention for listing, Lordship. 2nd September it was filed, Lordship.
What
AB, Lordship.
other senior courts are there?
After 7 years, this court is available. Above 7 years, Lordship.
This is above 7 years.
Yes, Lordship.
So, roster counsel. There is what is the offense?
Since is after 7 years, but at the present I am
Up to 7 years, there are other courts.
more than 7 years.
No, you tell me the offense. Only then you find out and then make mention.
My
May I please, Your Lordship? I beg to mention for listing of anticipated bail application, Lordship. It was last filed on Saturday, Lordship. Lordship, matter may come up on tomorrow, Lordship.
No, listing matters, senior courts are there.
It is above 7, Lordship. One section, Lordship, 141 DNSS is there, Lordship. Above 7,
Okay.
Lordship.
Okay.
May I please, Your Lordship?
Yes,
May I please,
Mr.
Your Lordship?
My lord,
What
on
by-
AB on BA Lordship, that is on that was fixed on 11/9/2024. Out of same FL Lordship, I tell an AB that will be listed on 11 Lordship.
No, I have not understood.
Out of same affair, Lordship, one case was fixed on 11.
Fixed on 11.
Yes, Lordship,
Now,
11.
why are you listing before this court?
Because the
mentioning
offense is, Lordship, more than.
More than 7 years.
Yes, Lordship.
You want,
On the same day, Lordship, 11, Lordship.
okay.
May I please, your lordship?
My lord, on 6/9, I moved AB lordship. And the another BA is fixed for city on 13 lordship. On that day, this matter was fixed on 13. But in the updated record, it is seen that the matter is fixed on 18 lordship. Matter may be taken on 13 lordship. Because from the same FIR, one BA is fixed on 13.
No, but what was the judicial order passed? It
Lordship.
was fixed on 18th.
No, lordship. It was fixed on 13, but perhaps wrongly, it is shown in the record.
No,
that,
for that we have to go through the orders. What order was passed? Suppose it was passed on, fixed on 18th.
No, lordship. It was in the open court, even before my submission, the honorable court.
Which court?
Court number 26, lordship.
It will remain as it is. It will remain. I cannot change orders passed by other courts.
I'm praying for listing of intention.
Not
Because-
listing, it is, you are praying for preponing the date.
Yes, lordship.
It is fixed on 18th, you want it to be,
Order was passed on for 13, lordship, but perhaps wrongly it is shown 18, lordship. Already.
unless the record is before us, how can we find out?
May I please, your lordship, I beg to mention the listing of withdrawal manner, anticipatory bailment for tomorrow, man.
What is the,
Anticipatory bailment.
what is the offense? More than 7 years?
326, my lord, IPC, my lord. More
What
than
is it?
7 years, my lord.
Okay.
Ma'am,
Obliged,
please, your lordship. I beg to mention for listing of the bail application, lordship, it was supposed to list on tomorrow, lordship.
Atul. More than 7 years. এখন court, only court হয়নি নহয় সাকসেন. Okay. What is the offense?
302 of IPC.
Okay.
Lordship, it was supposed to list on tomorrow, lordship, as per earlier order, lordship, but not listed in the main list, lordship. Kindly tomorrow, lordship.
Okay.
May I please, your lordship, I beg to mention for item number 38, CD was called for. 38.
Okay, we'll pass orders when the
Yes.
item is called.
Yes.
Wait for your turn.
May I please, your lordship, I beg to mention item number 16, my children have some personal difficulties, lordship.
16,
16.
1/6.
yes.
Lordship.
Heard,
At the adjourned of
what is your name?
M. Bulwa.
Heard Miss M. Borua, learned counsel for the petitioner who prays for an adjournment on the ground of personal difficulty of the conducting counsel. The prayer is allowed. When do you want? Let this matter be listed after a week on a date to be fixed by registry.
Tomorrow, lordship.
Okay, let this matter be fixed tomorrow. Tomorrow date will be.
First of all.
May I please, lordship, I BA 2259, may kindly be taken on today's item number 29. Both the cases are from the out of same FIR,
BA 2259, is it listed?
not listed, but
No.
226 is listed. Out of the same FIR
When it is fixed?
today, item number 29.
No, BA 2259, when it is fixed otherwise?
It is not fixed. It was fixed for 28th of August, 20 August. But before appropriate, before this court, appropriate court. Co-accused was allowed by this honorable court.
Okay, you give a mention memo.
Lord.
LCR also not received, my lord.
LCR is listed with the case number 2259. This same LCR.
Okay, you give a mention memo.
Give me mention.
May I please, your lordship? Your lordship, I pray for withdrawal of a bail application, your lordship, for tomorrow, your lordship.
More than 7 years?
Yes, your lordship,
Okay.
robbery, your lordship.
Okay,
Much obliged.
May it please your lordship, I'd like to mention for listing of a criminal petition lordship on 18.
Criminal petition, senior courts are there. You have to mention before senior. Three other courts are there.
Right.
This is the lordship. Lordship, I beg to mention, for listing of an anticipatory bail application for hearing manner on Thursday, if possible, manner.
Is it more than 7 years?
Manner that, conducted, co-accused bail application was heard and disposed of by this honorable court, manner. And lordship was pleased to fix the matter on 6/8/2024.
Thereafter, what happened?
Thereafter, it was not, listed, manner.
Okay.
Thursday, manner. Keep to your
Final petition from applicability for the.
May I please, Lord?
Yes.
I may be allowed to withdraw this petition, my lord.
Heard Mr. What is your name?
Yeah, my lord.
Heard Mr. A. Ahmed, learned counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant anticipatory bail application. Also heard Mr. P. Thakur, learned additional public prosecutor. The prayer is allowed. This case is dismissed on withdrawal.
Item number 2.
NDPS case, my lord, 21/3/29, arrested on 2/3/24.
Investigation going on.
Yes, my lord. Yes.
My lord, 190 days.
190
90,
days.
my lord. Since 2nd March 2024.
Well, I will get the instruction, my lord.
Then
regarding-
you will get bail in the trial court. Why have you approached this court? If
My lord, we have filed it on 16/8, but it was not listed till today, my lord.
Then, my lord, I will have to get the instruction, my lord, regarding filing of charge sheet. my lord.
when can we fix?
That too, my lord, I will try to get it.
Okay.
My lord, can it be listed on tomorrow?
Okay, tomorrow. Heard Mr. J. Bharali, learned counsel for the petitioner. Also heard Mr. P. Thakur, learned additional public prosecutor. Learned counsel for the petitioner submits that the petitioner has been detained behind the bars since last 190 days. On this, learned additional public prosecutor prayed for some time to get necessary instructions in this regard as to whether the charge sheet has been already laid or not. The prayer is allowed. Let this matter be listed again tomorrow, that is 10/9/2024.
My lord. Obliged.
Item 3.
Attempt 3 also, my lord, charge sheeted case under section 21C and 29 NDPS. I think.
Charge sheet already filed, or charge is already framed, your lordship.
Scan copy of LCR. may be
Yes,
possible.
your lordship.
Heard Mr. N. Jha, learned counsel for the petitioner. Also heard Mr. P. Thakur, learned additional public prosecutor. Considering the nature of offense involved in this case, perusal of the scanned copy of the case record of NDPS case number 201/2023 would be required for consideration of the instant bail application. Hence, call for the scanned copy of the case record. Registry to issue requisition for the same. Let this matter be listed again on 13/9/2024 for
Item 44. Item 44.
yes.
May it please, your lordship. But this is my charge sheeted case, my lord. What
Charge
happened,
sheeted.
lordship?
Yes, 302,
And here
326.
you lordship initially granted bail to the petitioners, my lord. Page 30. Page 30 is the order, my lord. 9 petitioners were there. And page 30, my lord.
Yes.
And against this order, my lord, I was filed for cancellation of this bail order on the ground that bail was earlier rejected, but it was not mentioned.
Okay.
And thereafter, your lordship pass an order, my lord. A conditional order, my lord. Page 38. Imposing 5,000 cost to the 6 petitioners. Page 38, lordship. And I was dismissed. However, 5,000 rupees was got page 47, paragraph 20, lordship.
Your bail was cancelled.
No, my lord. Your lordships directed to, my lord, deposit 5,000, my lord, cost, failing which, my lord, bail will be cancelled, conditional order.
Okay, so you failed to deposit
My
the
lord,
court.
on the next date, my lord, trial court was on leave. So we could not, my lord. And on the next date, my lord, we deposit the fine. We have an page 52, lordship, kindly see. Next date was 25/6/24. You lordship's order, my lord, 29/5, and next date was, my lord,
Okay, then what happened?
on 23/7/2024, my lord. Page 53. We deposited the fine. But as, my lord, next date was expired, and we could not bring this, my lord, fine, receipt of fine, my lord, to the trial court, my lord. They have been taken in custody, holding that our bail has already been cancelled in terms of the order of the Honorable High Court.
Yes, now what do you want?
So, my lord, we are ready to face the trial. Your lordship granted bail. We have never, my lord, misused the liberty, my lord. So, my lord,
No, no,
Already-
after you have been
Yes. This-
detained behind the bar, whether you filed an application
for
for
bail, my lord.
bail
Yes,
before
my
the
lord, that
trial,
was also rejected.
where?
Page 56 onward, my lord. Pre-bail order, my lord.
On what ground the bail was?
Only on that ground, my lord, we have failed to comply the condition of the Honorable High Court.
Yes, Mr. Upadhyay.
Otherwise,
Kotakot.
yes, because my lord, in spite of direction of this honorable court, they have not deposited that amount at that point of time. Tomorrow, my lord, again, they will, my lord, any order passed by they will obey any order passed by this trial court. Otherwise, offenses under section 302, 326 is also there. my lord. I will leave it to your lordship, my lord. Otherwise, my lord,
Where is the rejection order?
Yes, 56, my lord.
11 portion is page 58, my lord, last portion. It suggests that the accused persons
I think it's only against this application, yeah. Suppose against it.
Heard Mr. R. Ali, learned counsel for the petitioner. Also heard Mr. P. Botakot, learned additional public prosecutor. This application under section 483 of the BNSS, 2023, has been filed by the petitioners, namely 1, 2, 3, 4, 5, 6, 7, 8. 1, 2, 3, 4, 5, and 6. who are detained behind the bars since 23/7/2024 in connection with PRC case number 1420/2023 arising out of Sorbog PS case number 31/2023 under section 120B/4 147/341/326/302/435 of the Indian Penal Code pending before the Court of Learned Additional Chief Judicial Magistrate Borpeta. Learned counsel for the petitioner has submitted that all the above named petitioners had earlier approached this court by filing an anticipatory bail application, which was registered as AB case number 3674/2023. And in the said case, by order dated 29/11/2023, the above named petitioners were allowed to go on, were directed to appear before the committal court. Then you appeared before the
No,
committal,
we appeared in enlarged on bail.
appeared before the committal court on 16/12/2023. And on doing so, they were allowed to go on bail of rupees 30,000 each with certain conditions. Accordingly, the petitioners appeared before the Court of Learned Additional Chief Judicial Magistrate
On 16/12. Next page, madam.
on 16/12/2023. And in pursuant to the directions of this court, Learned Additional Chief Judicial Magistrate allowed them to go on bail of rupees 30,000 each. Stop. However, later on, an application was filed by the informant. Who filed the application?
Informant, madam,
Informant
is 41.
for cancellation of the anticipatory bail granted to the petitioners. Stop. By order dated 29/5/2023, though the prayer for cancellation was rejected, however, the petitioners were directed to deposit. Where is the cost?
Page 47, madam. Paragraph 20.
Deposit a token cost of rupees 5,000 each before the Secretary of District Legal Service Authority, which Dhubri or Borpeta?
Borpeta, madam.
District Legal Service Authority, Borpeta. On the next date fixed before the Learned Committal Court. Stop. It was also directed that if the petitioner fails to deposit the cost as directed by this court, their bail shall be treated as cancelled. Learned counsel for the petitioner has submitted that why you failed to deposit.
But on the next date, my lord, court was on leave. And my lord, on wrong advice, my lord, they did not deposit, my lord.
Learned counsel for the petitioners has submitted that on the next date fixed that is on
25/6/24.
25/6/25,
6, my lord.
6/2024, the presiding officer of the court was on leave. And due to miscommunication, the petitioners could not deposit the cost on the said date. When were you taken into custody?
Next date was fixed on 23rd of July, my lord. On 23rd of July, they have been taken in custody. They appeared.
The next date before the committal, it is further submitted by learned counsel for the petitioners that the next date before the learned committal court was fixed on 23rd July 2024. And on that day, the committal court took the petitioners, remanded to petitioners in judicial custody for violation of the directions to pay cost as directed by this court. Stop. Learned counsel for the petitioner has submitted that the petitioners had on the same day, that is on 23rd July 2024, deposited the cost as directed by this court before the Secretary, District Legal Service Authority, Borpeta, and also obtained a money receipt. However, when they filed bail application before the committal court by order dated 7/8/2024, their bail applications were rejected by the committal court.
Bail was rejected by learned session judge.
Oh, sorry, bail was rejected by the learned session judge Borpeta on the ground that the petitioners had failed to comply with the order of this court on the date fixed for such compliance, that is on 25/6/2024. Stop. Learned counsel for the petitioner has submitted that the delay in depositing the cost before the District Legal Services Authority, Borpeta, was due to communication gap, and they have now complied with the directions of this court by depositing the cost. Stop. Mr. Bothakur, what is your submission?
Considering in view of earlier, your lordship has cancelled the bail order because of the,
Learned counsel, no, bail order was not cancelled.
yes. Not
Cost was
cancelled.
imposed.
Yes, cost was,
imposed.
but according to the direction of this honorable court, they have
Learned
not
additional
imposed-
public prosecutor has opposed the grant of bail on the ground that the petitioners had failed to comply with the directions of this court in letter and spirit. Stop. I have considered the submissions made by learned counsels for both the parties and have gone through the materials available on record. It appears that initially the petitioners were allowed to go on anticipatory bail by this court by holding that their custodial interrogation may not be necessary and the petitioners are ready to face the trial. The committal court remanded the petitioners to custody only because of the fact that the petitioners failed to comply with the directions of this court within the time given to them for such compliance. Stop. Though they could not stick to the time given to them by this court, however, the petitioners have ultimately deposited the cost imposed on them to the District Legal Services Authority as directed by this court on 23/7/2024. Stop. Learned counsel for the petitioners has also submitted that the custodial detention of the petitioners may not be necessary for completion of fair trial of the case pending against them. And they are ready to cooperate in the trial. Stop. Considering the fact that the petitioners have ultimately complied with the directions of this court by depositing the cost to the District Legal Services Authority, Bongaigaon, Borpeta, as well as considering the fact that if the petitioners cooperate in the trial, their custodial detention may not be necessary. They are allowed to go on, the above named petitioners are allowed to go on bail of rupees 30,000 each with one surety of like amount to the satisfaction of learned. It is pending before the committal court
Committal court.
to the satisfaction of
Additional
learned
Chief
additional Chief Judicial Magistrate Borpeta with following conditions. The petitioners shall cooperate in the trial. Stop. Next. The petitioners shall not directly or indirectly make any inducement, threat, or promise that a condition to declare. With above observation, this bail application is disposed of.
Item number 5 earlier, scan copy was called for, my lord, as per my scan
Please.
copy not yet received. Office notice also there.
This is a second bail application, Lordship. Earlier bail application, Lordship previously passed an order with direction to approach the trial court, Lordship. So this matter may come up before the appropriate bail, Lordship.
Or some other court has passed.
Yes, Lordship.
Where?
5/8/24.
There was no scan copy was called for not yet received.
Why it is listed before this court? Okay. Heard Miss, what is your name?
M. Burwa, Lordship.
Heard Miss M. Burwell, learned counsel for the petitioner who submits that earlier a bail application filed by the petitioner
Yes, Lordship.
was disposed of by a coordinate bench of this court within bracket, and coordinate bench of this court, and therefore, as per the standing notifications in this regard, this matter should be considered by the same court. Stop. Considering the submissions made by learned counsel for the petitioner, the registry is directed to list this matter before the appropriate bench.
In this case, 21C, 25, 29 of the NDPS Act, my lord,
Charge-sheeted
charge
case.
sheeted case,
Yes,
scan
my
copy of LCR and CD. minute.
I am behind the bar for last 630 days, my lord.
How many in years?
It stands for 1 year, 8,121 days, my lord.
Okay, heard Mr. M.A. Chaudhary, learned counsel for the petitioner. Also heard Mr. P. Bhottakur, learned additional public prosecutor. What is the contraband?
My lord, 739 grams of heroin
No,
recovered.
why this has come before this court?
Lordship was pleased to reject the bail application earlier, my lord, which is
Okay.
Annexure 4.
Okay. Also heard Mr. P. Bhottakur, learned additional public prosecutor. This is for the second time the
Yes, my lord.
petitioner has approached this court seeking his bail stopped. Considering the nature of offense involved in this case, perusal of the scanned copy of case record of the special NDPS case number 170/2022 would be necessary, hence call for the same. Registry to take steps for requisitioning the aforesaid scanned copy. Let this matter be listed again on when
2 weeks after this.
16. Again on
My lord, can it be on 20, my lord?
29 to 2024.
On date of it.
May I please, Your Lordship? This is regular bail application matter. Petitioner is behind bar for 25 days. And in
25.
this 25 days, in this case, the petitioner was shown arrested on 16/8. And in another case, my lord, he was arrested on 12/7, today is 60 days. The FIS, my lord, page 20.
We'll call for the case diary.
Yes, my lord.
Lordship, 11, is another case matter.
11. Okay. Heard Miss P. Borwa.
Bora.
P. Bora.
291. Yes, my lord.
Learned counsel for the
26.
petitioner. Also heard Mr. P. Bhottakur, learned additional public prosecutor. Call for the case diary, fixing 11/9/24 for the case
And
diary.
avoid BA number 2600.
Let this matter be listed along with bail application number 2611
One.
of 2024.
Oblast.
From here, 312. No, no.
This petitioner has been arrested under section 1031, 1238.
103 is 302.
302.
Yes, yes,
Case diary
he-
would be
he-
required.
He has been in jail for 67 days till today.
Okay.
And he is a drug addict and NDPS substance. So he has to be stayed in rehabilitation center for 120 days till 25th September. But he has been arrested before that on 5/7, 2024.
Okay, heard Mr. H. Das,
BC Dacoity.
BC Deka, learned counsel for the petitioner. Also heard Mr. P. Bhottakur, learned additional public prosecutor. Perusal of the case diary would be necessary for consideration of the instant bail application, hence call for the same.
Well, for a
Fixing when,
On my lord,
16 or
when,
17, 9.
17,
17 September.
17.
May please your lordship. On page 10 is the FIR, your lordship.
What's the offense?
Offense is
Procreation of minor
kidnapping.
girl,
No.
of kidnapping.
Minor girl, no.
We'll call for the
Your
case diary.
lordship, the person has been recovered. Page 10 is the FIR, your lordship. Whatever your lordship, there were the informant's husband is a plumber.
Why the prayer was rejected by the other magistrate court or
No, reject, which is straight to one.
it was rejected? No,
No.
No.
Your
Your
lordship, it's a section 5.
case diary would be
Your
required.
lordship,
Yes,
kindly see once your lordship. Page 10 is the
You
FIR.
approach the magistrate court or sessions court before approaching this court? Yes or no?
But we have not approached.
Or you don't know?
No, we have not approached.
Then we have to peruse the case there.
Yes.
Heard Mr. S. M. Abdullah P. Learned additional learned counsel for the petitioner. Also heard Mr. P. Bothakur, learned additional public prosecutor. Call for the case diary. Fixing
From Romania, sorted maybe.
1999.
19 will be too long, your lord.
19-9.
It can it be little bit earlier.
He has to bring the case.
Romania.
And why have you approached directly to this court?
Lordship,
Just I'm querying.
procuring lordship.
Because-
They have engaged us here, but we didn't went to Romania.
Okay. 19-9.
Oblige, your lord.
The regular bail application, my lord.
Whether case diary would be
Yes,
required.
case there would be the 3021.
75 days to.
Heard Mr. H. A. Ahmed, learned counsel for the petitioner. Also heard Mr. P. Bothakur, learned additional public prosecutor. Call for the case diary. Fixing
On my lord,
75 days to.
29, 209.
29 for
Item number 57 also same, out of 75.
item number 57, also same. Same order. Same lawyer.
Always.
May it please your lord, regular bail application, today is 52 days, my lord. Offense against the petitioner under Dacoity, my lord. I am not involved, but merely on suspicion, my lord. My name is not there.
Mr. What is your name?
M. Hussain, my
M.
lord.
Hussain, learned counsel for the petitioner. Also heard Mr. P. Bothakur. Call for the case diary.
Nunmati police station, my lord.
CD on
Friday, my lord. Nunmati police station.
1999.
19-9, Monday.
Nunmati police station, my lord. Friday can be viewed. Nunmati, my lord.
Friday on 79.
17.
17.
In item number 10, yes, item, my lord, it was fixed on 29, but petitioner is today 75 days is in custody. So my lord, mandatory period will be over on 29,
19.
75 days petition.
No, it will not be over.
Yes, well, today is 75 days, then within the period of my lord.
Only after 15 days.
29 days, this is.
20.
20.
20.
I for 20, and.
Please, your lordship. Your lordship, 483 application, your lordship. The petitioner is behind bar since last 12 days, your lordship. The offense is registered under 96 of BNS, your lordship.
What is the offense?
Offense is kidnapping the minor girl, your lordship, of the informant.
Case diary would be required.
So, lordship, on 19th.
Heard Miss
IH Laskar.
Mr. I.H. Laskar, also Mr. P. Bothakur. Call for the case diary.
From my lord Manka sir.
19th, your lordship, if possible.
19?
Yes.
19-9 for case diary.
Hello.
Lordship. My lord, we kindly say FIR page 8, my lord. Well, here is the case, informant's brother was killed, late Yadali was killed. And in that case, the present petitioner was implicated as one of the accused person. Then in the long run, my lord, they were convicted. And this Honorable High Court has granted bail. Bail order I have annexed, kindly see page 18, my lord.
Whom?
This present petitioner.
Okay.
Present petitioner was implicated as a murderer of the present informant's brother, who was a home guard. Then, my lord, the latest session judge, additional session judge, this day convicted this petitioner along with another person. But in the Honorable High Court, my lord, they were granted bail because every thing was based on the basis of circumstantial evidence. So bail was granted, that is page 18 bail. Now, they were frustrated that in the murder case, bail was granted. So anyhow, they wanted to see me inside the bar. That's why the present FIR has been filed. Kindly see page 8, it is mentioned in the FIR also. Page 8.
No, what is the allegation?
Allegation, my lord, all sections are available except to 109, man. All others are available. And the lordship will kindly consider this suspect that I have been implicated in this case. It is clearly mentioned, my lord. For a moment, I read some lines of this FIR, page 8. With due respect, I beg to send the accused
What
number
is
2 and
109?
3.
What is 10?
109 is my attempt to commit murder.
Oh, 307.
Yes, sir.
But is this, my lord? If your lordship kindly go through the contents of the FIR,
Case diary would be required.
Yes.
You hit the,
Yes.
that is the allegation.
And earlier also, my
It
lord.
is it true or false? We don't know.
Yes.
Case diary would be required.
but
Heard,
with medical report, my lord.
heard Mr. M.U. Mahmood,
I
learned
short term
counsel
fixed,
for
my
the
lord, because
petitioner.
it is inimical case, my lord.
Also heard Mr. P. Bhattakur, learned additional public prosecutor, considering the nature of allegations leveled against the petitioner in the FIR, perusal of the case diary would be necessary for consideration of the instant bail application. Hence call for the case diary. Fixing
18-9.
fixing 18-9 for case diary.
Outline. Make please your lordship.
My lord, this relates to the criminal case filed by the petitioner lordship against her in-laws family. All other cases are continuing at Silchar lordship, and this case is remained at Koringa's lordship. So at this stage, let notice go, may go lordship. Other cases are already one case.
Press it later on.
Lordship.
Make please your lordship. My lord, in this case, my lordship, may kindly see the interim order, page 9, annex 1. my lord. Page 9, man.
What is the impugn order?
My lord, in this case, my lord, this petitioner is facing trial, and my lord, on that
You are
particular.
accused.
Yes, man. On that particular day, informant, my lord, PW1 is, my lord, present before the court, my lord.
It is a CR case or PRC case?
PRC case, my lord.
Okay.
But learned trial court, my lord, for the accused, also submitted representation, my lord, but for the.
Now, what is the matter? What happened on that day?
On that particular day, my lord, my junior counsel was there, my lord, due to certain, my lord, her headache, my lord. She could not able to cross-examine, my lord. She also called his senior also, my lord, but. My
So
lord,
now what do you want?
my lord, let my lord, one opportunity for cross-examination.
Who is the PW1?
Informant.
Where do he stay?
He is in unknown material. Known material, my lord.
You pay him cost, we'll allow your application.
Yes. Otherwise, my lord, that application was
We have submitted an application in 311, my lord. Learned court below was not entertained because, my lord,
after
we
3
have
months, my lord, they have filed this application under section 311.
no, my lord, on next particular day, we have submitted before the, my lord, trial court, my lord. That petition, lordship may kindly see.
311 for recall of,
Yes, my lord.
for the same permit. Then when that was rejected, what happened
My
to
lord,
that?
that was, my lord, the advice to, my lord, not press, because that court has no power. Because this order was, my lord, passed under section 309. So, my lord, there is no willful delay, my lord, that, my lord, on particular day, present also, my lord.
Now, why you did not cross-examine?
My lord, due to certain, my lord, health issue, my lord. In paragraph, my lord, the 10, I have explained, my lord. And we, my lord, this accused petitioner also submitted application, my lord. Counsel was also present, my lord. Because of, my lord, And this case is still for further DWA, my lord.
Fixed for?
Fixed on, my lord,
Now-
T12,
At what stage the case is fixed?
further DWA.
DWs.
Yes, T20, sorry. Only one witness examined. And fixed on, my lord, 3/12/2024.
Let them pay cost, my lord.
How much?
My lord, minimum, my lord, pending.
I will
Not
leave it,
full
regarding
detail.
costs, I will leave it to
You
lordship.
pay 5,000.
My lord,
It is,
maybe that's, my lord, because, my lord, I have stated the ground, my lord.
No,
Because of the health
the-
issue, my lord, only. That was correct, my lord,
heard Mr.
and this,
Heard Mr. G. Uddin, learned counsel for the petitioner. Also heard Mr. P. Bhattakur, learned additional public prosecutor. This application under section 528
now section 528.
/ 529 of the BNSS 2023 has been filed by the petitioner, namely Shakti Kumar Bari, impugning the order dated 22/2/2024 passed by learned Judicial Magistrate First Class, Kamrup Metro in PRC case number 541/2021. Learned counsel for the petitioner has submitted that the present petitioner is facing a trial. What are the charges against you?
My lord, 279/304 8. That is the accident case, my lord, one person. died.
Facing a trial for
In paragraph 3, my lord.
under for charges under section 279/304A and of the Indian Penal Code. So it is submitted that in the before the court of learned Judicial Magistrate First Class Kamrup Metro. Stop. It is submitted by learned counsel for the petitioner that the on 22/2/2024, the PRC case number 541/2021 was fixed for examination of prosecution's witnesses. Stop. On that day, the PW1 was examined. However, no counsel for the accused, within bracket the petitioner, turned up for cross-examining the PW1. And therefore, the trial court dispensed with the cross-examination and of PW1 and fixed the case for examination of remaining witnesses on the next day. Learned counsel for the petitioner has submitted that
There are 10.
on the date when the impugn order was passed, that is on 22/2/2024, the petitioner was present in the court. However,
No, my lord, petitioner submitted application
they
on behalf of the accused, my lord.
you are not
From the order itself, my lord. Accused is absent with step. Petition
no,
number.
petitioner was not present in the court as No, what is your stand?
My lord, accused was absent with step, learned counsel for the accused submitted application showing absence, my lord. And that thereafter, my lord, court, my lord, examined PW one. And my lord, when my lord called to the counsel of the accused, she was absent.
Now
And
what is your justification?
my lord, on that particular day, she, my lord, feel headache. She was a junior advocate, my lord. Poonam Sharma, my lord, I have stated. my lord.
Thereafter, whether you filed any application
Yes.
for the trial court?
Yes, my lord, that application was, my lord, lordship, kindly see page 10. For recall of the witness, my lord, on next subsequent date, my lord. Page 10, lord. Showing the reason, my lord.
This was filed after 3 months.
Next subsequent date. Earlier date was, my lord, lordship, it was 22/2/2024, and next date was 35/2024. On that day, my lord, filed the application.
Then why you did not press the same?
I praised my lord, but planet court below, my lord, I have stated categorically, my lord, he has no power to advise to go for,
Any order was passed?
no, my lord. But my lord, from the lordship may kindly see page 10. We have obtained the certificate, my lord. It was not pressed in left side, my lord.
So you have not pressed.
So, my lord, when, my lord, not allowed to entertain, my lord, we have no option.
So, can you please last line? Petitioner was not present in the court and he had filed an application to that effect. However, when the PW1 was examined, the counsel for the petitioner was also not found present in the court. Learned counsel for the petitioner submits that as the petitioner's counsel had some health issues, he could not appear before the court to cross-examine the PW1. Stop. Learned counsel for the petitioner has submitted that thereafter on the next date fixed, that is on 30/6/2024, the petitioner had filed an application for recalling the witness, that is PW1, for cross-examination. However, he was advised not to press the same, and therefore the said application was not pressed by the counsel. Stop. Learned counsel for the petitioner submits that if the PW1 is not allowed to be cross-examined, the petitioner who is facing trial before the Court of Learned Judicial Magistrate First Class would be highly prejudiced. Stop. I have considered the submissions made by learned counsel for both the sides.
My lord,
Anything?
My lord, no, he submitted that case is fixed on 3/12/24 for further PW, so that may be recorded.
Learned counsel for the petitioner has also submitted that the PRC case number 1451/2021 is fixed for examination of further prosecution witnesses on 3/12/2024. Stop. Considering the facts and circumstances of this case, this court is of considered opinion that the PW1, unless the veracity of testimony of PW1 is tested in cross-examination, it may not be of any use. It may not have it may not be of use during in the trial. And the petitioner may be prejudiced if the PW1 is not allowed to be cross-examined. The delay caused and the sufferance which the PW1, the difficulty which PW1 may have to suffer may be compensated by paying adequate cost to him. So in view of above, this criminal petition is disposed of with a direction that the PW1 may be again summoned for the purpose of cross-examination by the learned trial court, subject to the condition that on the day when PW1 appears before the trial court, the petitioner shall pay a cost of rupees 5,000 to the PW1 before cross-examining him. Stop. The payment of cost imposed would be condition precedent to the cross-examination of PW1. Stop. With above observation, this criminal petition is hereby disposed.
Malad, I have checked the address of the informant, but only Khargoli, man. Yeah. So, little less amount, I think. Obliged.
May I please, Your Lordship? This is a long pending trial case, my lord. Against the petitioner, Rashid was submitted on 201, my lord. But
201.
201. Against other accused, my lord.
Now, what do you want?
My lord, already 16 witnesses examined, my lord, since 2015 and now 2024, my lord. And petitioner is on version retirement, my lord. So either my speedy trial, my lord, or my lord, petitioner may be exempted for further appearance. That is the period, my lord. Nobody, my lord, named the petitioner, my lord.
No, you make such prayer if you want personal dispensation of personal appearance. You make such prayer before the trial court.
Yes. What about speedy trial, my lord? Because, my lord, ultimately, my lord, this is needed to conclude the matter, my lord.
The FIR is at page 16, my lord.
Is the FIR, my lord.
Very serious offense. my lord.
Yes, my lord. Yes, offense is serious, my lord. But petitioner was charged.
How many witnesses are there?
16. Total 23, my lord.
23 charge sheet. In the charge sheet.
Charge sheet.
How many have been examined?
16, my lord.
So only 7 witnesses are remaining. Why are you apprehending that it will take time?
This is going on, my lord, since 2015, my lord. Charge of frame, kindly see, my lord. Charge framed on, my lord. Page 33, 2015.
Now, what is your prayer?
That is the, my lord, two prayer. Either my speedy trial, my lord.
No, we read out the prayer. Where have you mentioned?
Yes, in the list. Lord. Page 12, my lord.
Yes, Mr.
My lord, otherwise, there is no prayer for any expedited. They have only challenged the entire proceeding of the case and also prayed for why the petitioner should not be exempted from his appearance in the further trial of the case. That prayer they can make before the trial court also. my lord.
It is there, my lord, and or direct the learned trial court to complete the trial by taking day-to-day trial of the case considering the long time already elapsed in the present proceeding. That is also there, my lord. So today, my lord, scan copy maybe call for, my lord. On the next day, your lordship will decide.
It will be use scan copy, my lord, unnecessarily, my lord.
No, whether it is any This is liable to be dismissed.
Yes, my lord, liable to be dismissed. My lord.
No, let us call for a report.
Yes,
When the charges were framed,
2015, my lord, page,
why it is taking so long?
page 33, my lord, yes.
Heard Mr.
Yes, sir, Ahmed.
H.R. Ahmed, learned,
present status report. My lord.
learned counsel for the petitioner. Also heard Mr. P. Bhattakur, learned additional public prosecutor. What is 438 of BNSS?
482, my lord, earlier corresponding.
You have mentioned what provision in your petition? You go through the cause title of your petition.
Yeah, 528, my lord, and 438.
What is 438?
397.
Earlier, my lord, 397, my lord, corresponding.
397 become 438. my
Corresponding to the.
lord.
So is it a revision or is it a criminal petition?
Criminal petition, my lord. That is why, my lord, it will be what is earlier, my lord.
This application under section 528 of BNSS, 2023 has been filed by the petitioner. Stop. The learned counsel for the petitioner has submitted that the main grievance of the petitioner in this case is that this case is pending since long. That is since the year 2016.
15.
Since the year 2015. And only 16 out of 23 listed prosecution witnesses have been examined. Stop. Let the notices be issued to the respondent. Since learned additional public prosecutor has appeared for respondent number 1, no formal notice need to be issued to respondent number 1. As regards respondent number 2 is concerned, the petitioner shall take steps for issuance of notice by registered post with AD, as well as by usual mode to the by usual mode within 7 days from the date of this order, returnable after 4 weeks. Returnable on 27 September 2024. Stop. Let also a status report of the sessions case number 79/2014 be called for from the Court of Learned Session Judge Kokrajhar to reach this court before the next date, list accordingly.
Published.
Lordship is a 528 petition, Lordship, under BNSS, Lordship, for passing of the affair, Lordship. Now, Lordship, has the affair arises.
Where is the affair?
Yes, Lordship, I'm telling you. Affair is at page number 24, Lordship, Annex 2. This affair arises between the girl and the boy, that after there is a love of affection, Lordship. Love and affection, Lordship.
Relevant portion, page 28. my lord.
After love and affection, Lordship. So
It is a long affair
Yes, Lordship, that's why I'm, but,
and very
but,
descriptive.
yes, Lordship, but, the entire affair, if you go, Lordship, nothing is there about the allegation that is, 417376309, Lordship. Nothing is in the affair. Though the section has been, checked, Lordship.
At what stage the case is pending? Investigation?
No, nothing we have done. No, Lordship. Since, it's a.
Okay, let us call
it's
for
a
the
FR.
case diary.
Yes.
Yes, Lord. But in the, I have the interim prayer, Lordship, that may be also.
What is the interim prayer?
Investigation at this stage, Lordship, he is a petitioner, is an MBA holder, and he's passing for the job.
Your lordship may kindly peruse only first
I have seen,
paragraph,
I have seen.
from the first.
Now,
paragraph
why
itself,
investigation should stop?
At this stage, Lordship.
Why? How it will hamper you if investigation goes on?
They will call me again, Lordship. I have already cooperated with the investigation, Lordship.
You
with the 2019.
continue to cooperate.
Yes, I'm willing, Lordship. At present, Lordship, I'm a MBA holder. I am in the search of the job, Lordship. Only for that reason, Lordship.
No, investigation cannot be halted.
Yes, Lordship. But however, Lordship, either kindly come to on the.
Heard Mr. B. Sinha, learned counsel for the petitioner. Also heard Mr. P. Bhattakur, learned additional public prosecutor. This application under section 528 of BNSS 2023 has been filed by the petitioner, namely Somendu Hazra, praying for quashing the FIR dated 3/6/2021, filed by the respondent number 2, on the basis of which Jalukbari PS case number 615/2021 under section 417/376/309 of the Indian Penal Code was registered. Stop. Issue notice to the respondents. Since learned additional public prosecutor has appeared for respondent number 1, no formal notice need to be issued to respondent number 1. As regards respondent number 2 is concerned, the petitioner shall take steps for issuance of notice upon respondent number 2 by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable on 27th September 2024. Since it also appears that perusal of the case diary of Jalukbari PS case number 615/2021 would be necessary for consideration of the instant criminal petition, hence call for the same. Register the learned additional public prosecutor shall produce the case diary.
Updated CD along with the present status of the case, because cases of 2021.
Yes, okay.
Only CD would be enough because
Yes.
It said happened in 2019, Lordship. FR laws in 21, Lordship. After 1 year gap.
shall produce the updated case diary on the next date fix list accordingly.
Only for that reason, I'm praying for the interim, Lordship. 2019 incident, 2020 it was Lord, Lordship.
No interim.
From 39,
Fixed on 27/9.
Deeply, please.
Deeply.
May please your lordship, the anticipatory bail application, case diary will be required, madam. But what had happened, 2 laborers had come and sold fake gold to the people of a particular area. Subsequently, when they found out that this was fake gold, they
Fake
demanded them fake gold. They demanded money. These laborers were unable to pay money. So the villagers, including the petitioner, tied up the laborers, called their family members, said that give the money and take them away. The family members informed the police. Police came and recovered them and lost this FIR. So now it's a case under 364A, kidnapping for ransom. The case diary will be
Heard
required.
Mr. S. Nawaz, learned counsel for the petitioner. Also heard Mr. P. Bhattakur, learned additional public prosecutor. Perusal of the case diary would be necessary for consideration of the instant anticipatory bail application. Hence call for the same.
from 26/9.
On
26 should be too long. Shorter
Give a
date,
shorter
next
date.
week.
From 19/9.
19/9. Let this case be listed again on 19th of September.
I'm deeply obliged, madam.
May I please, my lord, this is my lord, 482, my lord, petition. Now lordship will find, my lord, page 17 is the, my lord, FIR. The, my lord, vernacular, my lord. Now entire allegation is against the, my lord, husband, the petition number 1. And because of, my lord, family dispute, the petition number 2 is the father and 3 is the BDB secretary. They several occasions, my lord,
What are the offenses?
offense, my lord, attempted to commit rape. That is the, my lord, entire gist of the case, my lord. Attempted.
Where is the? Isad Matiu.
Apply.
Item 22.
Wait, page your lordship. My lord, this is an application under section 482 of the BNS lordship. The inquiry is bail. Page 9 is the FIR, your lordship. The FIR discloses your lordship relationship between two consenting adults. The petitioner
What is the offense?
offense is only 69 is non-bailable. It's
What
sexual-
is the
sexual
offense?
intercourse by deceitful means. And others are bailable section, criminal intimidation.
Vernacular is page 13, my lord.
What is the offense?
Offense, my lord, under section 376, 420, my lord. There is no specific allegation of 376, my lord. It says, my lord, since last 3-4 years, they are in relationship, my lord. With consent, my lord. There is,
Where is the FIR?
vernacular is page 13, my lord. 1-3. Both are measure, my lord.
Yes, Mr. Parashar.
Now, this is, my lord, from last several years. This is going on. Last 4 years.
Yes, sir.
So, those same type, this is registered under 376.
What is your submission?
Since last 4 years.
4
that
years,
is-
my lord. There is
that
no
is-
specific allegation, my lord. So and so date he commit such things. my lord.
Regarding delay also not mentioned, my lord. Only torture to close the relationship since last 2 months. Because of the torture, my lord.
Yeah.
Case registered.
376 will not come, my lord, in this case. At best, my lord, adultery, my lord, that is now no offense, my lord.
Heard
Yes, sir, Ahmed.
Mr. H.R. Ahmed, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 482 of the BNSS, 2023 has been filed by the petitioner Susuman Datta versus alias Nihal Datta, who is apprehending his arrest in connection with Kokrajhar PS case number 176/2024 under section 420/376 of the Indian Penal Code. The gist of accusation in this case is that on 1/8/2024, the victim had filed an FIR. The victim had lodged an FIR before the officer in charge of Kokrajhar police station, inter alia, alleging that father and mother have been arrested.
Father and mother, the forwarding report, I have annexed your lordship, page 13, and grounds of arrest of the forwarding report reflects that the father has assaulted Manna Salim, page 13. And multiple litigations are there. From the FIR itself, it reflects that he was released on bail on.
Maybe please more. This is a for 82 bell applications. Here are the allegations under section 103, subsection 1 of PNS. And,
Where is the FIR?
FRA page number 10. This is the translated copy.
You are named in the FIR.
Yes. There are
Then-
four number of accused in the FAR, and the accused, one number accused has already been arrested, and he is the husband of the victim. And here the present petitioner are in-laws of the victim. And so far, here my humble submission, I was say that
How the victim died?
the allegation that they found to be died and left at the porch of the house. This is the allegations, but nobody is an eyewitness in this case. And my humble submission here, and this is the husband and wife live separately, and the in-laws are nowhere connection with this alleged incidents. And during the expire of the wife, the husband has already been arrested, and they have the two minors son, and they were with the petitioner, my lordship. In such a situation, if the petitioner get arrested, then it will be difficult to take care of them, my lordship.
Now, what is your relationship with the husband of the victim?
Yes, sir.
You are
Is the petition number 1 is the father-in-law of the victim, and petition number 2 is the mother-in-law of the victim.
and
And petition number 3 is the brother-in-law of the victim. And so far the girls, minors, sons are with the petitioners, and they are taking care. Even if
Yes,
they get arrested,
Mr.
it will be
Parashar.
difficult to take
My
care of.
lord,
let them appear.
my lord,
Petition number 1 and 2 maybe.
1 and 2, my lord, at this is one brother-in-law may not be, my lord, at this is my lord.
Yes.
Otherwise,
Heard Mr.
consolidated is
Heard Mr. P. Thakuria, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. This application under section 482 of the VNFS has been filed by the petitioners number 1, 2, and 3, who are apprehending their arrest in connection with Patasar CPS case number 141/2024 under section 103 within bracket 1/3 within bracket 5. Yes. What is 3 within bracket?
It's a common intention, my lordship. So far that there are more than one accused person. Therefore, this section has been inserted.
Earlier 34.
earlier 34, I think.
34 maybe. So,
Common, earlier 34.
Okay. 3 within bracket 5 of BNS, 2023. The gist of accusation in this case is that on 8/7/2024, one Habez Uddin had lodged an FIR before the officer in charge of Bhawanipur police station, inter alia, alleging that the petitioner, that the accused persons named in the FIR had subjected the daughter of the informant to cruelty, and thereafter on 7/7/2024, the dead body of the daughter of the first informant was found at the porch of the house, and it is suspected that the accused persons named in the FIR had killed her. Stop. Learned counsel for the petitioner has submitted that the main accused in this case is the accused number one, namely Ramzan Ali, who is the son of the petitioner number 1 and 2 and brother of the petitioner number 3. And he has already been arrested. Stop. It is also submitted by learned counsel for the petitioner that the petitioners live separately from the accused from their elder son, from the accused number 1, Ramzan Ali, who used to stay with the victim. Stop. It is also submitted by learned counsel for the petitioners that the petitioners are in no way involved in the offense alleged in the FIR, and they are ready to cooperate with the investigating officer. Stop. On the other hand, learned additional public prosecutor submits that the perusal of the case diary would be necessary in this case, hence call for the case diary. Fixing
23rd, my lord.
23rd September for case diary. However, considering the fact that the main accused has been arrested, the petitioners, I'm allowing all 3 petitioners named herein above are directed to petitioner number 1 and 3 are directed to appear before the investigating officer of Patasar CPS case number 141/2024 within a period of 10 days from the date of this order and cooperate in the investigation. The petitioner number 2 is also directed to cooperate in the investigation. Stop. If they do so within the stipulated period of time, in event of their arrest in connection with Patasar CPS case number 141/2024, the above named petitioners are allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Condition number 1 and 2. Let this case be listed again on which date is fixed? 23rd 9.
May I please, your lordship? Is an application under section 482 of BNS, your lordship. The case has been registered against the petitioner under section 61(2) and 108, your lordship, abatement to suicide, your lordship.
Abatement to suicide.
Abatement to suicide.
Okay.
Earlier it was 306, your lordship, now 108, your lordship. Will you kindly come to page 9. This is the FIR and the vernacular original is at page.
Committed suicide.
A wife of the informant, your lordship, committed suicide. And your lordship will kindly see there is no specific allegation against me, your lordship, except saying, your lordship, with due respect, I would like to inform you that I am staying in Bangalore for the last 1 year on working purpose, taking advantage of the situation. 2 persons, namely Bhaikon Kolita and Miss Gitimoni Kolita. I am the Gitimoni Kolita. I stay at Bangalore. With ill intention and prevalent manner has been mentally harassing my wife. The accused number only different tactics has been trying to establish love relation with my wife, and the accused number 1 has also been spreading rumors about my wife that he is in love relation with my wife, due to which my wife had a total mental breakdown on so and so. at around 2:30 committed suicide at our own residence. It is mentioned the suicide note says committed suicide.
What is the allegation against the case number 2?
Against two only
Yeah.
spreading the rumor, but
Not even spreading the rumor, it is also against
2, there
accused
is no
number.
specific.
no.
Let her appear. Heard Mr. S. Bothakul, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. This application under section 482 of VNSS number 23 has been filed by the petitioner Srimati Geetamuni Kolita, who is apprehending her arrest in connection with Silapathar PS case number 157/2024 under section 61 within bracket 2/108 of BNS 2023. The gist of accusation in this case is that on 17/8/2024, the husband of the deceased, namely Shri Thaneshwar Hazarika, lodged an FIR before the officer in charge of Sisibor Gaon Police Outpost, inter alia, alleging that the informant is staying at Bangalore since last 1 year and taking advantage of his absence. 2 persons, namely Bhaikon Kolita and the present petitioner, are mentally harassing his wife. Stop. There are specific allegations made against Bhaikon Kolita in the FIR to the effect that he was trying to establish love relationship with his wife and was spreading rumor to that effect also, due to which the wife of the informant suffered a mental breakdown, and on 15/8/2024 at about 2:30 p.m. she committed suicide. Stop. Learned counsel for the petitioner has submitted that though the petitioner has been named in the FIR, however, apart from the statement in the FIR that the petitioner has, apart from the general statement in the FIR that the petitioner is had mentally harassed the wife of the informant, no specific allegations has been made against the petitioner. Learned counsel for the petitioner has also submitted that in the FIR itself, specific allegations have been made in detail against the co-accused Bhaikon Kolita only. Stop. It is also submitted by learned counsel for the petitioner that the petitioner is ready. CD would be required, or we can dispose it off.
At this stage, what the neighbors say, interim may be getting on 25.
Learned additional public prosecutor, on the other hand, submits that perusal of the case diary would be necessary. Hence, call for the case diary, fixing 25/9/2024 for case diary. Stop. However, in view of the submissions made by learned counsel for the petitioner as discussed herein before, the petitioner is directed to appear before the investigating officer, is directed to cooperate with the investigating officer. Will you appear?
Yes, Your Lordship. Only thing, Your Lordship, I stay in Bangalore, Your Lordship. At least 10 days time may be given.
Shall appear before the investigating officer of Silapathar PS case number 157/2024 within 15 days of the date of this order, and shall cooperate in the investigation. if she does so within the stipulated period of time, comma, in the event of her arrest in connection with Silapatar PS case number 157/2024, the above named petitioner shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions, condition number 1 and 2. Lists,
then
Oh.
on 15 days, then 30th of September.
list this matter again
30.
on 30 September.
Deeply obliged.
Along 21, huh?
May please your lordship.
Fifty-four.
55 and 56 are wrongly listed in motion, my lord. Already, my lord, 55 is, yes, 55 is fixed on
Yes.
12/9 for case diary.
Case diary is not
Lordship,
there.
may I
No,
submit,
no.
lordship? On last occasion, item number 54 was listed on 2/9/2024, lordship. And this honorable court passed an order to list this matter along with 55 and 56, lordship. 2/9/24, lordship.
CD was called in 55 on 12/9
12/9.
and in 56 actually 17/9. So CD, my lord, may be listed on 12/9, my lord.
Lordship, in other cases, the petitioners are on interim, lordship. So at least this
Same FIR.
same FIR, lordship. Item number 21, 54, 55, 56, lordship. 21, 54, lordship, till the next date of listing, lordship.
Separate order in 54. In 54.
54 also, my lord, not granted interim, only list appropriate bench. Interim granted on 55 and 56.
Heard Mr.
P. Bordle, lordship.
P. Bordole, learned counsel for the petitioner. Also heard Mr. K. Bosho, learned additional public prosecutor. This application under section 482 of BNSS, 2023 has been filed by the petitioner Imdad Chand, who is apprehending his arrest in connection with the Boca PS case number 148/2024 under section 420/ under section 120B/420/468/409 of the Indian Penal Code. What is the accusation?
Lordship, FIR is at page 13, lordship.
Allegations are serious, my lord.
It is an FIR log on the basis of an official note signed by the Honorable Chief Minister or something.
What is the allegation?
It is allegation is with regard to financial irregularities and malpractices under Ayushman Bharat, lordship. The doctor and these pharmacists are on bail, lordship.
Who is Imdad Chand?
Lordship, he is the accountant, lordship.
You may not be on the same footing.
That is,
Lordship, till 17, lordship, I will appear. And item number 21 is the wife of the injured, lordship.
Wife we will give.
Lordship, till 17, lordship. If anything
is-
comes, lordship, then his bail may be rejected, lordship, because
accountant and all this one.
Abu Sharif Akanda, then doctor and these pharmacists are on bail, lordship. Till 17, lordship. If anything found, lordship, then he may be rejected. His bail may be rejected, lordship. Because his father is suffering from cancer, lordship.
The gist
Document
of-
also I have annexed, lordship.
The gist of accusation against, where is the affair?
At page 13, lordship.
Against the present petitioner is that on 13/8/2024, the Joint Director of Health Services, Hojai, Assam, had lodged an FIR before the officer in charge of Doboka Police Station, alleging certain financial irregularities and malpractices under Ayushman Bharat PMJAY scheme by the petitioners and some other co-accused persons. Learned counsel for the petitioner has submitted that in the meanwhile, the other co-accused, namely Abu Sharaf Akanda
Lordship,
and Muhammad Anwar Hussain
Lordship.
and
Lordship,
And-
Abu Saraf Akanda,
And
Muhammad
Is-
Hussain
Islamuddin.
and Islamuddin. Lordship.
and Islamuddin are already allowed to go on interim bail by a coordinate bench of this court. And their cases and case diary has been called for
On 17.
on 12/9.
Malak in 55/12/9, but in 56/17. Now, Malak, their statement has to come. Malak, all the
Seven-
cases may list
70.
77.
On 17/9/2024. Stop. Hence, stop. Learned additional public prosecutor also submits that the case diary may be required, and as the case diary has already been called for in connection with AB case number 2244/2024 on 17/9/2024. This case may also be listed along with the said case on 17/9/2024. The prayer is allowed. Let the case diary be called for. Let this case be listed again on 17/9/2024. In the meanwhile, as other co-accused persons are granted interim protection, the present petitioner is also directed to appear before the investigating officer of the Boca PS case number 148/2024 within a period of 7 days from the date of this order and cooperate in the investigation. Stop. If they do so, if he does so within the stipulated period of time, the petitioner shall be allowed to go on bail of interim bail of rupees 30,000 with one security of like amount, subject to the satisfaction of the arresting authority with following conditions. Condition number 1 and 2. List accordingly on 17/9. In application, in item number 55, you are there in all the cases.
Lordship,
In item number 55, list this matter again along with bail application number 2309 on 17/9.
interim to be continued.
The interim shall continue till next day. In item number 56, list this matter.
Already, Malak, this is
No.
fixed on 17/9.
No,
Already this.
And Malak,
but why it is listed today?
Malak, there is a order in
Okay.
item number 54.
So today an order would be required.
No, yes.
List this matter on 17/9/2024 along with AB case number 2309/2024. The interim order shall continue. Now 21. This heard Mr. P. Burwa, P. Bordole as learned counsel for the petitioner and Mr. K.K. Parashar, learned additional public prosecutor. This application under section same as 54. Everything would be same. All of changes lagibo. That the petitioner Hasina Begum, let me dictate it. This application under section 482 of the code of the BNSS, 2023 has been filed by the petitioner Hasina Begum, apprehending her arrest in Doboka PS case number 148/2024 under same section. Huh? Why are you apprehending arrest?
Not
You are not named.
Not named, Lordship, but wife of the accountant, Lordship. I'm wife of this Imdad son, Lordship.
No, then you may be wife, but why are you
The
apprehending?
police are searching for Imdad son as well as his wife, Lordship. That's why I am approached before the Honorable Court, Lordship.
Learned counsel. The gist of accusation same. This learned counsel for the petitioner has submitted that though the petitioner has not been named in the FIR, however, as she happens to be the wife of one of the accused, namely Imdad Chand, police is also searching for him, for her. Stop. On the other hand, learned additional public prosecutor has submitted that a connected anticipatory bail application number 2244/2024 in the same case, arising out of same police station case, has been fixed on 17/9/2024, where case diary has already been called for. Hence, he prays for fixing this matter on 17/9/2024 for case diary. Stop. Let this case be listed on 17/9/2024 along with the AB case number 2244/2024. So, learned counsel for the petitioner has submitted that 3 of the co-accused have already been granted interim protection by this court, and therefore he seeks interim protection for the present petitioner also. He also stopped. Considering the fact that the present petitioner is not named in the FIR and her apprehension of getting arrested is only because she happens to be the wife of one of the co-accused, namely Imdad Chand. It is hereby directed that she, till arrival of the case diary, she shall cooperate in the investigation. Stop. If she does so, in the event of her arrest in connection with Doboka PS case number 148/2024, she shall be granted interim bail of ₹30,000 with one security of like amount, subject to the satisfaction of the arresting authority with following conditions, number 1 and 2. Let this case be listed again on 17/9/2024 as directed herein above.
Oblige, Your Lordship.
We are clear. This matter is taken over at too low.
What is, we will admit it and fix it for him.
Already the matter is admitted and this matter has come up for that integrity application. No, I have
Tell
already filed their
LCR
objection and LCR also received.
What is the matter?
10 years fine.
Offense?
NDPS.
NDPS was, but cause list has not shown LCR receipt because of the, we have also not done so.
Objection also filed.
But the matter has been already admitted.
Already admitted on 5/4/2020.
What is the contraband?
That ganja was 33
much?
from 3 persons.
33 kg.
Yes, 33 from 3 persons, and there is no material to show that these persons were coming together. That is specially accepted. And some inventory, regarding inventory also, there is some discrepancy. I will place that to you.
We have to go through, man, otherwise, so many cases, there is a.
Let him be prepared. We'll take it up tomorrow, day after. When can you be ready? On a hearing day,
Thursday, madam?
Thursday. Heard Mr. A. Ahmed, learned counsel for the appellant. Also heard Mr. K. Parashar, learned additional public prosecutor, who submits that he needs some time to go through the case record before he makes his submission, and hence prays for some time. The prayer is allowed. Let this matter be listed again on 12 September.
I have
In
to leave, huh?
admission college.
In orders column.
In orders column.
I have to, I have 204.
29 on logout.
59, madam.
Made this.
Sorry, madam, CD not receiving.
CD not received.
In the morning, I mentioned one more item, the DA. See,
What is the offense?
And
NDPS.
NDPS, commercial council.
Let the case diary come.
LCR has come, Your Lordship.
Mhm.
The case number BA 2259.
NCR Assembly.
I made the mention in the morning.
22?
It is a charge sheeted case.
Lordship,
Charge sheeted case.
charged case.
Oh, it is,
LCR. has come.
LCR, madam, is not shown. Can be the Ah. 259 আজি কিমান আছে?
29
Oh, production.
You go through it
No, we have to go through, madam.
in the second half or when?
Second, madam.
We'll take it up at second half, in the second half.
No, আজি আহিছে production.
Please, Lord. Lord, 483 application, my lord. Petitioners, they were arrested, my lord, on 17/7. So they were, my lord, 54 days behind the bar. The FIR filed by the police, my lord. The FIR is at page 14. Merely on presumption, FIR has been filed. It's 14, my lord.
What is the allegation?
Okay.
What is the allegation?
Allegation, my lord, the allegation of, my lord, preparation of Dacoity.
Oh, preparation.
And ground taken by the police, my lord, that since the vehicle has passenger of mixed communities and also from different district of Assam, therefore, my lord, the police, my lord, suspected that they were coming in a vehicle for committing Dacoity in some way.
Read the FIR. Read the FIR.
FIR, my lord. Page 14, my lord. With reference to above, I would like to inform you that yesterday I received an information from source that a group of dacoits are planning to commit dacoity in Borshabari PS area. I entered this information by Shimla PS GDE number so-and-so, dated 15/7/2024, and informed my superior officer at Shalwari, who was at Shimla PS itself at that time. Accordingly, SDPO and we formed a multiple teams to apprehend the group of dacoits. As per input, the gang would be coming in Mahindra SUV car and would pick up local contact from Shimla. At around 9:10 p.m., the silver Mahindra SUV was spotted near so-and-so Shimla. On being asked to stop by us, the SUV fled away from the spot. Immediately, I informed the matter to Pachala PS that SUV vehicle is fleeing towards Bagmara side via Shalbari and that it needs to be intercepted at Pachala's shop. After a brief says the SUV vehicle bearing registration number Sessions was intercepted by Pachala police at Pachala's shop. It was found that vehicle had 6 persons, namely so and so. And the vehicle was driven by Johar Ali. Since the vehicle had passenger of mixed communities and also from different district of Assam, it was established that the group had assembled to commit Dacoity in Buxar district. As some media persons had gathered at the spot, and there was strong suspicion that if the news would flash in TV, the other members may abscond from the place. As DPO Shalbari instructed me to take the suspected person to vehicle to Zala PP, which is nearby, so that search and seizure could be done. The vehicle and the passengers were taken to Zala PP and thereafter search was made in presence of independent witnesses under videography. During search, mobile phones were recovered from each of the suspected persons. The names of suspected persons and were searched in so and so. Name and identities are given below.
Now, what is your case?
The offense is not.
Why the vehicle fled away?
Suspecting police, they may not have driving license. So many.
My lord, before pointing out the materials in the present case, your lordship may kindly peruse, my lord. How
And
many
they have-
numbers of cases regarding the same type of offense, my lord?
They have listed
Against the
the cases.
How many?
Those are habitual, my lord.
No, my lord.
Offender, my
It's
lord.
the FIR itself. my
There
lord.
are number of cases registered against the present person, and on that particular day, only, my lord, police, from the source information, police would come to know that these accused persons from different districts, my lord, were gathered in a particular place for committing dacoity, my lord. On the basis of that specific input, my lord, police tried to apprehend the XUV vehicle. And after apprehension, all these accused persons who are involved in cases of dacoity under various police stations gathered in a particular place. So, my lord, prima facie, it appears that why these persons from different districts all are involved in various dacoity cases, my lord, why gathering in a particular place along with all together, my lord. And thereafter, on the basis of that specific input, while police tried to apprehend the vehicle, then, my lord, initially they tried to, my lord, flee away, and thereafter, my lord, later on being getting the information, the Patsala SOC of the Patsala police station, my lord, able to, my lord, apprehend that vehicle, and thereafter, my lord, these accused persons apprehended. And from the case diary, your lordship, I have flag mark last one, how these persons are preparing to commit a dacoity in the residence of one Kobiras of a particular place, my lord, on a particular day. That is everything is
In this case,
yes, in this case, my lord.
Case 14
Regarding
itself.
that, my lord, statement of the, and in fact, they admitted, and the statement of the present accused persons are all the co-accused persons is also available later portion, my lord, I have flag mark some of the persons. And these
Case 14,
persons
my
are,
lord,
they are habitually involved in committing dacoity in, my lord, various districts of Assam, in various places, my lord.
the police has given the chart, my lord, in FIR itself, my lord. One case against petitioner one, that is, my lord,
And
in 2000.
immediately, my lord, those earlier days are
There is-
gone. Immediately, police apprehended someone, my lord. There is a, my lord, CCTS, my lord, network, my lord, crime and criminal tracking network and systems, my lord. And from that, my lord, police immediately can find out all these.
no, in this case, any materials was found
Yes, my lord.
where they were going.
Yes, my lord, their statements are available in the case diary. I have flag marked some of the important points, my lord, while at that point on a particular day where they were preparing to commit dacoity in the house of one Kobiras.
When were you arrested?
Arrested on, my lord, they were apprehended on 15/7, thereafter forwarding report on 17/7, my lord. And during the, my lord,
How many days have lapsed?
54, my lord.
54 days.
54.
The offense is 7 years punishable.
No, my lord, 19.
310(6). What is the punishment? Ten years. You can detain them only till 60 days.
Yes. Other considering. Yeah, they are some, otherwise they are habitual offender, my lord, they
Yes,
again.
but the offense is under 310(5) and 310(6). So and what is the progress apart from their statement?
Progress, my lord, investigation is going on, otherwise not yet. I'll get the present status of the investigation, my lord. The lordship may sort, after 3 days, the lordship may kind of fix them, I will get it.
Present status is in the case that
It is,
Regarding
yeah.
if any other, my lord. Details, my lord.
no, why do you need their detention? You may seek instructions regarding that,
Yes, my lord.
whether further custodial detention is necessary or not.
Except mobile, nothing has been recovered. And there is no conviction, my lord.
Because, my lord,
Mayor, my lord, filing FIR by police on presumption. That
because
to
not
mixed
only the
communities,
present
boys
case,
are
why these
gathering.
accused persons, you know, involved in many other criminal cases, cases of dacoity, why they gathered in a particular place on that particular day, my lord, of different districts, my lord.
These are all on suspicion.
So prima facie, it reflects that, my lord, those persons are preparing to commit dacoity in a new place, my lord.
Now, what is your prayer?
My prayer, your lordship, may kindly 3 days time may be allowed. I will get the instruction regarding their further custodial interrogation.
Okay. 3 days more.
54 days.
My lord, they are habitual offenders, my lord.
Heard Mr. R. Ali, learned counsel for the petitioners, also heard Mr. P. Bhattakur, learned additional public prosecutor, who has produced the case diary of Simla PS case number 50/2024, which was called for in connection with this case. He submits that additional public prosecutor submits that though there are incriminating materials against the present petitioners in the case diary, he needs some further instructions as regard the necessity of further custodial detention of the above named accused persons in this case, of the accused persons in this case or not. Hence he prays for 3 more days to get such instruction. The prayer is allowed. Let this case be listed again on
13/9. 12/9.
again on 12/9. The case diary shall be retained till next date.
Lordship 32 also same order.
This city,
Lordship.
this case,
Same city, Lordship. Would have taken 31 and 32.
32 also same order.
Lordship, one more prayer is there, Lordship, regarding item 47, Lordship. Case there is also not there and it will go to appropriate bench, Lordship, item 47. 47.
Some other bench has taken up. Item 47,
Lordship, it will go to similar bench, Lordship. The co-accused were granted bail by court number 3, Lordship.
learned, item 47. Learned, heard Mr. S. Muni, learned counsel for the petitioner. Also heard Mr. P. Bhattakur, learned additional public prosecutor, learned counsel for the petitioner. has submitted that the co-accused in this case have been granted bail
Lordship.
by a coordinate bench of this court. Hence, this matter should also be considered by the same bench. Stop. The registry to list this matter before appropriate bench. And list the same accordingly.
Well, Lordship.
No, no date. Registry will finalize the problem.
Section is 109 BNS lordship for the listing AB lordship. In the morning, I come.
What is the punishment for 109?
Life imprisonment lordship.
Okay.
Tomorrow we have.
By the loss. 302. And already charged, she submitted charge, fake evidence also started, my lord. And he is in custody for last 162 days. So why I am only at that time, my lord, because of the further custody required on the state time. Husband and wife. And your lordship can see FIR is page 14.
Who is the petitioner?
Petitioner is one, he is pharmacy husband. Allegation that he has killed his wife.
Killed his wife.
Wife, this is the allegation.
Okay.
Page 14. Starts from page 13.
Yes.
you lost
By
page 14.
stabbing.
Hello?
By stabbing.
Yes. Now your lordship kindly see, my story is, kindly have a look to my paragraph, my lord, you will get whole story, my lord. 18 years of marriage, 2 sons, 13 years, about 13 years. Page 6, paragraph 7, your lordship kindly see. In fact, it is accidental one, my lord. He came, he is a pharmacist in Silchar Polytechnic. So this lady is having some relation, ultimately when he came, got red-handed. Then, but that person, he took a vow to attack him. And that ultimately hit the wife, and ultimately she injured there at the hospital. There she died. Page 6, paragraph 7. Just have a look.
No, charges are framed.
Everything is fair.
And
2 witnesses already examined as my Malan friend is saying now. So, another custody of 25 listed witnesses, man. 25 listed witnesses.
who have been examined?
I think.
Is there eyewitness?
One is, no, one is complainant and another witness, my lord, to the PDP member, my lord. And here is the, my lord, both the side as the eyewitness, my lord, of the incident, my lord.
Okay,
And they are not yet examined, my lord. They are the, my
They
lord.
are not with me, my lord. I am in custody. How can I?
No, no,
I am in custody.
Let them be examined.
my lord, my lord.
But when they will be examined, this is the whole question.
Next witness.
Next witness, my lord, because already they could have
They
done
should
it.
be examined at the earliest.
My lord, my lord.
Next date, is here. Yes.
No. As per my lord, last order, it was 19/7 already over, my lord.
No, already no.
Somebody is opposing also.
My lord.
You are
If I am.
father, complainant.
No, wife.
I am the victim here now.
Victim.
Victim is no more.
No, victim is sister of the deceased here.
Now, page 24, my lord, issues summons to the PWs, namely Ashad Ahmad Chaudhary and Farooq Ahmad Chaudhary, fixing life.
Where is the list of, where is the charge sheet?
Yes, that should is last page.
Who are the eyewitness?
Page
Both the child, my lord.
Both this.
13 years old, both the child. Here they are examined 10 and 11, my lord. Witness, PW, 10 and 11.
They can be examined.
My
At,
lord.
they can be examined as next witnesses. Instead of waiting for
10
10th,
and 11.
10 and 11. They can be called as next witnesses because they are eyewitness. Then we can. Not before, not before, because your father.
My lord.
If you go out.
Father, my lord, I am not under control of them.
But still, it will be difficult to.
I am nowhere. I lost my job, everything is gone, my lord. And no fault of mine. That's true, my lord. If a husband comes and find, and he got red-handed somebody, my lord.
In the 164, both of them implicated them, and they have seen.
That's why I'm not saying, my lord. At this stage, because already 169 days, whether anything will be, my lord, that way. Only for the custody required, only my question is.
No, we can dispose it off with a direction
My
that
lord, my lord.
Like, you know, also
two
keep pending.
witnesses may be
No.
examined.
We already have some special days so that they can inform us. You'll also pass order, we'll place it there.
And the trial court will examine them as next witnesses.
My lord.
Then you can
My
move,
lord.
before the trial court.
No, man, let it remain here, man. Huh? No, if your lordship, my lord, in that way, my lord, if after examination of two children, if my bail is considered, some positive order is given, my lord, so otherwise it should come here, my lord.
No, session judge may consider because only two eyewitnesses are there.
Yes.
Others are not eyewitnesses.
No.
Yeah.
Only 2%, dead of
Then
night,
by imposing certain conditions,
that is the, that your lordship may dispose in that.
heard Mr. H.R.A. Chaudhary, learned senior counsel, assisted by Mr. A. Ahmed, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 483 of the BNSS, 2023 has been filed by the petitioner, namely Afzalur Rahman, alias Afzalur Rahman, who has been detained behind the bars since 31/3/2024 in connection with Sessions Case number 121/2024 under section 326/302 of the Indian Penal Code. Learned senior counsel for the petitioner has submitted that the petitioner is facing a criminal trial in Sessions Case number 121/2024, which is pending before the Court of Learned Sessions Judge
Anything out of my signature, please, number.
Kachar, arising out of Silchar PS case number 280/2024, which is pending before the Court of Learned Sessions Judge Kachar, Silchar. It is submitted by learned senior counsel that the criminal prosecution in this case was initiated on filing of an FIR by one Arshad Ahmad Chaudhary on 30/3/2024, wherein it was alleged that the petitioner had stabbed his wife, and as a result of which the wife sustained severe injuries, and later on she succumbed to her injuries in Silchar Medical College and Hospital. Learned senior counsel for the petitioner has submitted that the petitioner has been detained behind the bar since last,
Yes.
how many days?
169 days.
169,
162 days.
162 days.
As on today.
And there are 25 listed witnesses in the charge sheet, out of which only 2 have been examined till now. Learned senior counsel submits that the petitioner, it will take, and the trial is unlikely to conclude at the earliest, as there are 23 listed witnesses yet to be examined. He submits that the petitioner is ready to face trial and shall cooperate in his trial and is ready to abide by any condition imposed while granting his bail. And therefore he prays for allowing the petitioner to go on bail. On the other hand, Mr. B. Sharma, learned additional public prosecutor, has submitted that the has opposed the grant of bail of the petitioner on the ground that the offense involved in this case is heinous in nature. He also submits that two of the eyewitnesses, who are the minor sons of the present petitioner, are yet to be examined. And there is every likelihood that if the petitioner is released on bail at this stage, he may influence the said witnesses. Stop. What is your submission?
My submission is also, that is also my submission.
Mr.
A.M. Khan.
A.M. Khan,
A.M. Khan.
A.M. Khan, learned counsel for the
Informants.
learned counsel for the informant.
I am not for the informant, your lordship. I am the sister of the deceased. I am the victim, your lordship.
So, but he,
Because here in the informant is your lordship, I think she is the nephew of the
Ahmed,
House.
Asad Ahmed.
honor, your lordship, wherein the state has tenant.
Learned counsel for the victim, within bracket, sister of the deceased, has also opposed the prayer for bail on the same ground. Stop. I have considered the submissions made by learned counsel for both the sides. It appears from record that though the charges were framed
charge frame on 19/7.
on
19/7.
19/7/2024,
Charge frame.
and the recording of evidence of prosecution witness has started, however, only two witnesses have been examined, namely the complainant as well as one.
Number one and Ashad Ahmad Chaudhary and Jalur Ahmad Chaudhary.
Jaruk
I
Ahmad
have taken up my letter.
Chaudhary, who are listed as prosecution witness number
1 and 2.
1 and 2 in the charge sheet. It appears from record, it appears from the, who are the sons? It appears from the charge sheet that the
But a copy of Lordship, and I think it is missing in my petition.
the eyewitnesses.
Huh? It was episode 27.
Oh, page 27.
Last of it.
Eyewitnesses, namely
10 and 11.
Farhan Kaif Rahman
And
and
Afrin
Rehan Ahmad and Afrin Kaif Rahman, who are the son and daughters, sons of children. I will correct it. Farhan Kaif Rahman, who is the son of the petitioner, and Afrin Kaif Rahman, who is the daughter of the petitioner, are listed as prosecution witness number 10 and 11 in the charge sheet, and they are yet to be examined. Stop. Considering the relationship of the eyewitnesses with the present petitioner, this court is of considered opinion that unless both the eyewitnesses, namely Farhan Kaif Rahman and Afrin Kaif Rahman, are examined by the prosecution side, it may not be proper to release the petitioner on bail, as there would always be a probability of his influencing his children in his favor. Stop. Therefore, this court is not inclined to grant bail to the petitioner at this stage. However, considering the fact that both the eyewitnesses are listed as witness number 10 and 11 in the charge
Right.
sheet. The trial court is directed not to go as per seriatim of the list of PWs in examining the said witnesses, in examining the prosecution witnesses. Instead, every endeavor should be made by the trial court to examine the eyewitnesses at the earliest. That is as the next witnesses to be examined. Stop. After examination of the said eyewitnesses, the petitioner may approach the trial court for seeking bail by filing an application for bail if so advised. If such an application is filed, the said application may be considered by the trial court as per law. Accordingly, this bail application is disposed of.
Months.
Also, the petitioner is in custody since 18/7. As on today, 53 days.
How many days?
53 days.
What is the offense?
The offense alleges 87 of BNS.
What is
That
87?
is abduction.
Abduction.
Corresponding provision is earlier 366.
366.
Here,
Of the IPC.
victim is of but my lord, victim is of 16 years.
Victim is on?
Victim is of 16 years, but POSCO Act is not yet added in the.
No, whether allegation of any sexual.
Yes, your lordship may kindly produce this 164 statement on the vital code portion.
Is 10 years.
Just kindly after some time, my lord, I will- this matter, my lord, after some time. Not one for the silence.
36.
May I be the lodgers? The case diary was called from.
We have not received case diary, my lord.
I prefer short statement from Hazun.
Heard Mr. N. Mahajan, learned counsel for the petitioner, also heard Mr. B. Sharma, learned additional public prosecutor, who prays for some more time for producing the case diary. The prayer is allowed. Let this matter be listed again on. Give a date, 18/9.
Obligement.
Item 47.
May I please have this? Serious corporal losses. And this FIR is in page number losses 9. Your lordship. May I read lordship?
Case diary is there?
Case diary here.
Yes.
That's it. That is fine. So actually the informant and the accused petitioner lordship, they developed their last relationship since last 3 years lordship. And since last 1 year lordship, they have been living together as a husband and wife lordship in a rented room at Rukmini Gaon lordship. But due to the misunderstanding lordship, they have entered into a quarrel lordship, and the informant lordship seeks help from some of his friends, and they want to settle the matter amicably, but somehow their dispute turned to a hostile situation lordship. And the friends of the informant lordship very badly beaten up the accused person and finally handed over him to the police lordship. And the victim is lordship 25 years old. It is a fact lordship. To the allegation of commission of rape, she is 25 years of age. Consensual relationship.
Are you married?
My lord, married already 2-3 children are. To the accused person.
Married to somebody else?
Yes.
Okay.
Still, Lordship, the informant is still residing
Mhm.
in my rented room. Lordship.
No, the manner in which you have tortured the victim.
It's allegation. Lordship.
And also, my lord,
Under
Actually,
160.
FIR was lost at the instruction of some of his friends.
How many days?
47 days.
my lord, let him remain for some more days, my lord. In
Do
160,
you require him for investigation?
my lord, in her 161 statement, she taken help from the social media that I was torturing here in the flat and confined here, and somebody may help. Thereafter, her all the friends going to the spot and rescue her. Thereafter,
Another thing, Lordship, she regularly doing her duty, Lordship, from that room, Lordship. How can she is a torture?
how she said in the 160?
Regularly attending.
Heard Mr. A. Rahman, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 483 of BNSS, 2023 has been filed by the petitioner Shahid Ali, who has been detained behind the bars since 24/7/2024 within bracket for last 47 days in connection with this PS case number 755/2024 under section 127 within bracket 2/64 within bracket 1/76/75 within bracket 2/308 within bracket 4/30/304 within bracket 2 of BNS, 2024. The gist of accusation in this case is that on (23/7/2024), the victim had lodged an FIR before the officer in charge of Dispur police station. Dispur police station, inter alia, alleging that the petitioner has been harassing her mentally as well as physically by confining her in a room at fourth floor of house number 4, Milanpat, Beltala, Rukmini Nagar, and made obscene videos of her and subjected her to and blackmailed her to post those videos in social media. Stop. She also submits that she was rescued after she made appeal for help on social media. Stop. Learned counsel for the petitioner has submitted that. What is your submission?
Lordship, the fact of the Lordship, they have been living together as just like a husband and wife since last 1 year in a
That,
rented room. Lordship.
that the petitioner is having a consensual relationship with the victim since last
1 year.
1 year. And the allegations made in the FIR are not true. Stop. He also submits that the petitioner has already been detained behind the bars for last 47 days. And considering the custodial length of detention, he may be allowed to go on bail. On the other hand, learned additional public prosecutor has vehemently opposed the grant of bail to the petitioner and has produced the case diary of this court PS case number 755/2024. Stop. That he is a married person, it has been found out during investigation.
Well,
I have considered the submissions made by learned counsel for both the sides and have perused the case diary which was called for in connection with this case, including the statement of victim which is recorded under section
183.
183,
183 BNS.
160, 180,
Three.
section 183 of BNSS. Stop. There are sufficient incriminating materials against the petitioner in the case diary, and the manner the victim has been tortured as appears from her statement made in statement under section 183 of the BNSS. This court is not inclined to grant bail petitioner at this stage.
Some of the lawsuits, can annex 3 lawsuit, page number 60 lawsuit. She herself executed an affidavit lawsuit showing his no objection if the.
No, my lord, it is not, my lord, applicable such type of, my lord, offenses, my lord.
Still lawsuit, she has been residing in my rented room lawsuit.
Where is,
No, my lord, say yes.
now let me see where, at page?
Lawsuit, page 16. Railway 17 lawsuit, 17. This is the outcome of some misunderstanding lawsuits.
No, not at this stage.
My lord. If it is, my lord, misunderstanding how she has taken help from the social media, my lord.
At that moment, she was in dilemma also what she should to do. She cannot determine lawsuit. And at the instruction of his friends lawsuit, she lost this affair. Already lawsuit 47 days in custody lawsuit. And there.
Where is the original?
Original submitted in the session code lawsuit. There below.
Session code rejected after.
Yes, sir.
What was the last name? Not now.
Well,
Accordingly, this bail application is rejected. Send back the case diary.
my lord.
Hello, Mr.
No, we did not. CD was called for your lordship.
My lord, here charge sheet submitted, my lord.
Offense is under section 302, 30, attempt to murder,
Yes,
My lord,
109.
my lord, 109.
310 is also there. 140 is also there.
Now, what is your submission?
But she is in custody since 11/7, almost 59 days, you know. Since already charges have been submitted, your lordship, so there is no chance of hampering or tampering with the evidence. Lordship may.
No, my lord, letting it here
Lordship
before
may
the
consider-
court. Not here, my
Before
lord.
that court, which you are asking
My
him
lord.
to appear,
My,
that is a committal court.
my,
It does not have the power to.
my lord. But here, after investigation found materials, my lord. Against him and thereafter charge sheet submitted, my lord.
We don't know the materials. What are the materials?
My lord,
You may pray before the trial court.
my lord.
Heard Mr. U.K. Burman, learned counsel for the petitioner, also heard Mr. B. Sharma, learned additional public prosecutor, who submits that though the court case diary was called for, however, in the meanwhile, charge sheet has already been laid against the petitioner. Stop. In view of submissions made by learned additional public prosecutor, this bail application is disposed of with an observation that petitioner may approach the learned trial court and may pray for regular bail before the said court, if so advised.
Right.
With above observation, this bail application is disposed of.
Here charge sheet number is 168 of 24,
Yes, charge sheet number.
dated 6/9/24.
Charge sheet number लिख देंगे.
Right. Information my lord, here we have not received case diary, my lord.
My lord, so for my instruction is concerned, my lord, charge sheet is submitted on 3/9/24. Your lordship. CS number 287/24. Under some bailable sections, your lordship.
Then you appear before the trial court.
My lord, that is his submission, my lord. I have not received any.
No, but we will record his submission.
My lord, my lord, my lord.
My colleague has verified in this court of CGM court, my lord.
Heard Mr. A. Rahman, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who submits that the case diary has not arrived and prays for some more time for
Right.
producing the case diary. On the other hand, learned counsel for the petitioner has submitted that he has information regarding the fact that the case diary, that the charge sheet has already been laid in this case, bearing charge sheet number
287
287/24,
24 dated 3/9/24.
dated 3/9/24. He also submits that charge sheet has been laid under bailable
Bailables.
sections, bailable offenses. Stop. In view of the submissions made by learned counsel for the petitioner, this bail application is disposed
Bail
of.
may be granted, your lordship.
You pray before the trial.
My
court.
lord.
Disposed of with an observation that the petitioner may approach the learned trial court and may move a regular bail application before the said court, if so advised. With above observation, this bail application is disposed of.
Not so bad.
Yes, my lord, today is 60 days.
Heard Mr.
P. Chakraborty.
P. Chakraborty, learned counsel. What is the offense?
Offense, he is a, my lord, there.
60 days offense.
Yes, head doctor, my lord. He is, my lord, in a pharmacy.
P. Chakraborty, learned counsel for the petitioner. Also heard Mr. P. Bothakur, learned additional public prosecutor. This application under section 483 of the BNSS, 2023 has been filed by the petitioner Naveen Kumar Mishra, who has been detained behind the bars since 11/7/2024 in connection with Bhangaghar PS case number 94/2024 under section 120B/495/466/465/471/304/511 of the Indian. You have verified all the provisions are.
Lordship.
Maximum punishment is
Lordship.
10 years.
Because there is no reported case 304, it will affect part 2, my lord. That it will, maximum imprisonment is 10 years, my lord. 10 years, then it will be 60 days, my lord. 304, at best, there is no reported case of any date. And even if assuming, my lord, then it will, part 2 will be affected, then it will be 10 years, my lord.
Learned counsel for the petitioner has submitted that in the instant case, all the offenses under which the case has been registered against the petitioner No, for none of the offences under which the case has been registered against the petitioner, the punishment is more than 10 years. And hence the maximum period of detention under what provision? What is the equivalent of 167?
Yes. 183, it will be 187.2, my lord, yeah, as per BNS.
187.2. As per, he therefore submits that as per section 187 within bracket 2 of the BNS, as the maximum period of detention for which the present petitioner may be detained is 60 days, and he has already completed 60 days today. Stop. Therefore, he prays that the petitioner may be allowed to go on bail. On the other hand, learned additional public prosecutor has produced the case diary of Bhangagor PS case number 94/2024 and has submitted that though there are incriminating material against the petitioner in the case, however, for none of the offences against which the petitioner has been charged, punishment is more than 10 years. And hence, the maximum statutory period of detention under section 187 clause 2 is 60 days only. Stop. Considering the submissions made by learned counsel for both the sides and considering the period of detention undergone by the present petitioner, the above present petitioner, he is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate, Kamrup Metro, with following conditions. Condition number 1 and 2. With above observation, this bail application is hereby disposed of.
I'm deeply obliged.
Ma'am.
58.
Yes, in this case, my lord, already submitted. Last occasion, my lord, Honorable Court, my lord, directed me to take instruction regarding health status of the, my lord, grandmother. Because here FIR is by a girl.
Case 8 is the FIR, my lord.
FIR is by a girl.
What is the offense?
Offense under 306, man, and 506.
But yes, Ambarish,
The FIR was registered in the year 2022, my lord. Case number 8 is the FIR, my lord. And I was arrested on 2024, my lord, on 25/8, my lord. At least some apprehension was there that I will misappropriate the property of the deceased man, deceased father of the informant man. It was the only apprehension. In fact, I was the one who was taking care of the grandmother man.
FIR is by granddaughter against her stepmother. And allegation is that because of the mental torture, father commits suicide 2 years earlier. Now,
When he committed suicide? Who committed suicide? The father of the informant.
Father of the informant committed suicide.
And the allegation is that he abated. He abated
No,
because
the stepmother.
you are the stepmother.
My lord.
Stepmother.
And the second wife.
The second wife.
After the
And
death of the first wife.
And now only the grandmother is around 85 years old. She is in the home alone, Malad. Regarding that, Malad, Honorable Court directed me to take instructions how the present health condition. Malad, I have communicated the police also, Malad, now on last 8/9. yesterday, my lord, medical examination was done, my lord, she is fine. Due to always some problems are there, otherwise, not no.
This
But
2 years, my lord,
now-
I have been taking care.
Now already, my lord, this case succeeded against Purobidas.
I will regularly appear, my lord. I will appear.
Always has-
Otherwise, my lord.
No. It is tribal by which court?
Sessions court.
Session-
Now this, my lord, my mother-in-law and my daughter is alone, my lord. I was the only one who is looking after them, my lord. After 2 years, I have been arrested in the case, only to file, my lord, because charges was not filed, as I was not arrested. My lord.
When were you arrested?
25/8, my lord. 16 days. And I'm 49 years old. My lord.
No, for filing charge sheet, your arrest is not necessary. The
Yes.
law is clear. Arrest of accused is not necessary.
Right.
Now what should be done? What is your submission?
Fact is that, yes, succeeded, but that incident 2 years earlier,
Heard, Mr.
H.
H. Ali, Learned Counsel for the petitioner. Also heard Mr. K. Parashar, Learned Additional Public Prosecutor. This application under section 483 of BNSS, 2023 has been filed by the petitioner, Srimati Purobide, alias Purobide Bhattacharjee, who has been detained behind the bars since 25/8/2024 in connection with Patasi Lambari PS case number 39/2022 under section 306/506 of the Indian Penal Code. The gist of accusation in this case is that one Sagarika Bhattacharjee had lodged an FIR on 16/2/2022 before the officer in charge of Patasi Lambari police station, Inter India, alleging that her grandmother is 85 years of age and residing alone in Kahilipara colony, house number 20, Bylem number 2, Jyotsna Enclave, Guwahati Kamrup Metro, and her only son, late Shubhendra Bhattacharjee, who was the father of the informant, had committed suicide on 9 February 2022. It is alleged in the FIR that the present petitioner subjected the father of the informant to mental and physical cruelty, resulting in his committing suicide. Learned Counsel for the petitioner has submitted that the petitioner has been looking after her mother-in-law since the death of her husband for last 2 years. And the allegations made in the FIR against her are not true. He has also submitted that the custodial detention of the petitioner is not necessary, as it is revealed that the charge sheet has already been laid in this case. Stop. Learned additional public prosecutor has also submitted that the charge sheet has already been laid in this case, bearing charge sheet number
153/24 dated 28/8/24.
so. As the incident involved in this case is alleged to have happened 2 years ago, and as the charge sheet has already been laid, this court is of considered opinion that, and as the petitioner is also a lady, this court is of considered opinion that her custodial detention at this stage would serve no purpose if she otherwise cooperates in her trial. In view of above, the above named petitioner is allowed to go on bail of ₹30,000 with one surety of like amount, subject to the satisfaction of London Chief Judicial Magistrate, Kamrup Metro, with following conditions. Number one, she shall cooperate in her trial. Number two, she shall not directly or indirectly make any inducement, threat, or promise to any person who may be acquainted with the facts of the case so as to dissuade such person from disclosing such facts before the trial court. With above observation, this bail application is disposed of.
I do.
My lord, here we have not received case there, my lord. I prefer for that, my lord.
My lord, already 3 to 4 adjournment has been sought on account of case diary.
Heard, Mr. What is your name?
Divyansh Rathi.
Heard, Mr. D. Rathe, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor,
A short
who
date.
prays for who prays for some more time for producing the case diary. The prayer is allowed. When?
19th, my lord.
Let this case be listed again on 19th of September 2024. The interim order shall continue till next year.
Much of it.
My lord, in this case, my lord, the statement was recorded on 19/1 bail.
You
Interim
are
bail
on
was there,
interim.
my lord.
You are on interim.
Interim, my lord,
My lord,
19/1.
here interim, my lord, but here his statement is not available in the case diary, my lord. In the last occasion also.
But he appeared, whether he appeared before
Appeared,
the
my
order.
lord.
Not, my lord, he did not here. Last order, I will note, my lord, 21/6/24, my lord. Here, সম্পাদক উত্তম চন্দ্ৰ দাসৰ বিৰুদ্ধে সংশোধন, my lord, কৰায়ত্ব কৰাৰ চেষ্টা চলাইছিল যদিও পদকীয়জনক কৰায়ত্ব কৰিব পৰা নাই। পদকীয়জন পলাতক অৱস্থাত আছে। Perhaps he has not appeared, my lord.
You have
But-
not appeared,
Appeared, my lord. He has instructed me, petitioner.
but have you,
Yeah, let it be then confirm, my lord.
21/6, my lord.
when you were granted interim bail?
Yes, my lord. He was
When?
granted bail 19/1/24, my lord. Thereafter, he
No.
appeared.
When you appeared?
I will take instruction, my lord.
You take the instruction?
Yes, my lord.
You also take instruction?
After some time, my lord.
But materials are there, my lord. Sufficient materials against him, my lord.
He has completed.
Are
the
you
work
on
also.
bail?
I am on bail, my lord, and also completed the rest of
No,
the work.
no.
That's it.
This court directed interim bail subject to your appearance.
My lord, my lord.
Yes, my lord.
Now, whether the IO granted you bail? No,
He appeared, my lord, and he recorded his statement.
but it is not there.
My lord, from the
Yeah.
21.
And whether you furnished any bail bond,
Possibly he has submitted, my lord, because it is
then take
involved.
proper instructions.
My lord.
Just, my lord, after some.
Tomorrow,
Tomorrow, my
Tomorrow,
lord.
my lord.
on
And next
request.
bail, my lord.
Whether he has appeared or not, that instruction I will take.
Okay.
It is like 21/6.
On request of learned counsel for both the sides, let this matter be listed again on 10th of September 2024. In the meanwhile, the council would seek necessary instructions from their respective parties. The case diary be retained till tomorrow. The
My lord.
interim order shall continue till tomorrow.
But in this case, my lord, petitioner, my lord, never contacted with me. Possibly he has appeared, but I have no instruction, my lord. Your lordship may pass necessary order.
Return CD.
What
Well,
has,
CD not received, my lord, in the after the, it was earlier received, my lord, it was sent for up to date CD, my lord.
heard
Or-
Mr. H. Das, learned counsel for the petitioner, also heard Mr. B. Sharma, learned additional public prosecutor, who prays for some more time for producing
Up to
an
date CD.
updated CD, case diary. The prayer is allowed. Let this case be listed again on
My lord,
20,
20, my lord, 20.
29 for case diary. The interim order shall continue till next day.
What is it? No, no. It is copy from 20, my lord.
May I please, your lordship? I am on interim, my lord, and I have appeared before the.
Because he appeared,
My lord, he interim granted on 5/8/24. But as per the office note, my lord, he till my lord 24/8. My lord, there is nothing to show that he has appeared, my lord.
when have you appeared?
My lord, because here one entry is of 10/7/24. Next entry is 24/8/24. That from registry, he has got that from us, he has received that summon for sending the case diary. Only that entry. That entry is 24/8. Earlier entry is 10/7. In the meantime.
When have you appeared? When?
After granting interim, I have
You
not provided.
tell us the date so that he can take instructions.
But in the diary, my lord, nothing. My lord.
He informed me he has appeared before the IA.
My lord, he
Then-
can telephonically ask them and then I will talk with them. My lord.
You take instructions. When? We are fixing it some other day. Or
Yes, yes,
today
yes.
itself.
Thursday,
Tomorrow.
Heard Mr. S. Y. Ahmed, learned counsel for the petitioner. Also heard Mr. K. K. Parashar, learned counsel for the petitioner, submits that the petitioner was granted interim
24/9.
bail on 5/8/2024. And in pursuant to the said order, he has appeared before the investigating officer. However, comma, learned additional public prosecutor who has produced the case diary of Dhemaji PS case number 251/2021 has submitted that no endorsement
Till 24/8/24. my
till
lord.
24/8/2024 is there in the case diary, showing that the petitioner had appeared on before the IO. The petitioner, learned counsel for the petitioner is requested to take further instructions from the petitioner and let this court know as to on which date he has appeared before the investigating officer. The additional public prosecutor shall also take instructions from the investigating officer as to whether the petitioner has been allowed. The petitioner was arrested, no, whether the petitioner has appeared before the investigating officer or not. Had he been granted bail, it would
This
have been
certainly
there
is
in
not-
the,
I have not found the certificate copy of the order also. my lord. The order should be in the my lord, CD. my lord. That
if
is
you
also
have
not-
not appeared, then your bail will be rejected. Let this case be listed again on 13th of September.
13. আপনি এটা খবর বলে মুখ ইনফর্ম করে দেখেন The CD not received. my lord. Is an interim.
None appears for the petitioner on call. Learned additional public prosecutor has submitted that has prayed for some more time for producing the case and prayer is allowed. Let this matter be listed again on
on 25.
25/9/2024. The interim shall continue till next day.
Till 9.
Mayor, please, Lord. Lordship, out of same of her lordship, two bail application has been filed, one pre-arrest and regular lordship. In pre-arrest bail application, 3 petitioners, and regular bail application, 2 petitioners, and all of from same family members, lordship, of same family. What happened, lordship? Wife assaulted the husband. Husband took shelter in her parents' house, lordship. Then the family members of the wife went to the house of parents' house to bring him back. Accordingly, fight took place. Both parties injured. 2 FR filed, lordship. Cross FR has been filed. This is the fact, lordship. Now the rest will submit, my friend.
Now, let us take one by
I
one.
am from husband's side, lordship. All the petitions are husband side, and lordship. So far, the house paper is concerned, lordship.
Oh,
it
who is
not against the-
arrested? Who has been arrested? In bail application number 2529. Let us take one by one.
Yazul Chaudhary and Ibadul Chaudhary.
Who are they?
They are the brothers of the husband, lordship.
Husband has not yet been arrested.
No, lordship. Husband is not participated in the fight. That husband. Okay.
Husband was assaulted by wife.
Why? They are not party in the case.
Husband and
Family
wife
members
are
fight.
not.
The family members fight.
Here,
They are silent.
lordship, it will be clear from the my lord FIR, my lord.
Where is the affair?
In,
Page 9.
My lord.
in item number 45.
How many days you are behind the bus?
Yeah, 56 days.
56.
Yes.
What was the injury?
My lord, here. 2% injured, my lord, as per FIR, my lord. আমি স্থানীয় ৰাইজৰ সহযোগত মোৰ দেউতা ইছলাম আলী আৰু জেঠা মনছেৰ আলীক বাইহাটা চাৰিআলিস্থ অভেল মাল্টি স্পেচিয়েলিটি হস্পিটেলত ভৰ্তি কৰা হয়। বৰ্তমান মোৰ দেউতা ইছলাম আলী গুৱাহাটী সাগৰ হস্পিটেলত মৃত্যুৰ সৈতে যুঁজি আছে। 2% injured, my lord. Here we have found only one injury report, my lord, regarding Islam Ali, my lord. From the Sagar Hospital, my lord.
No, what is the injury?
Injury here, my lord. Nature of injury is grievous. Grievous. And Monser Ali not receive any information, my lord, medical report.
Now, what is your submission?
My submission is that from the statement of the complainant and other witnesses, my lord, they have assaulted together, my lord. And my lord, from the statement of all the names were here, my lord, all whoever arrested and not arrested, my lord, all of them were mentioned by the complainant, my lord. He has seen the occurrence also, my lord. I have checked my lord, statement of complainant, my lord.
সিহঁতৰ এজনৰ injury হৈছে। সিহঁতো পলাতক, সিহঁতৰ এজনৰ injury হৈছে। 15 দিন পিছত। Injury আছে, তোমাৰ।
Munna Chaudhary.
My lord, Munna Chaudhary, first he has assaulted as per statement of the complaint. From the weapons which were used for fishing, my lord.
Who are the petitioners in this case?
My lord, here in the AB, my lord,
No,
Munna
we are taking a bail
Bail,
application.
my lord. Yazul Chaudhary and Ibadul Chaudhary. Yazul Chaudhary and Ibadul Chaudhary.
So again, Yazul and Ibadul, there are increment. The complainant has stated that he has seen.
They will implicate me as lordship, lordship. One person pursuant to the affair also arrested, lordship, page 30 of my bail application. One Genuine Ali, who is released on after 15 days, lordship. Same allegations.
Not same allegation, because
Page 29 forwarding report of
in
the
your assault,
lordship, they entered our house, lordship. That is clear from section 329, subsection 4 added against them, lordship. Page 29, lordship. We have not entered their house. They entered our house. 329(4) brought against them, lordship, not brought against us. This is criminal trespass, house trespass. Lordship, they have spent 56 days, lordship. Further custody detention may not be required. In regular bail application may be considered, lordship.
yes.
Their bail application may be considered.
But my
The
submission,
main person who assaulted using fishing
my lord,
is Munna Chaudhary.
my lord, is
Thereafter, they assaulted.
they assaulted, my lord.
Now, they are already behind the bars for last 56 days.
My lord.
Now, why do you need their further detention?
My lord.
How, Mr. What is your name?
A.T. Sarkar, lordship.
A.T. Sarkar, learned counsel for the petitioner. Also had Mr. B. Sharma, learned additional public prosecutor. This application under section 483 of BNSS, 2023 has been filed by the petitioners, namely number 1, Yazul Chaudhary, number 2, Ibadul Chaudhary, who are detained behind the bars since when?
15,
Since
15/7/20.
Forwarding, my lord, 15/7.
15/7/20.
since 15/7/2024, within bracket for last 56 days, in connection with Baihata Chariali PS case number 184/2024, under section 189 within bracket 2/126 within bracket 2/109/118 within bracket 2 of BNS, 2023. The gist of accusation in this case is that on 14/7/2024, one Zakir Ali had lodged an FIR before the officer in charge of Baihata Sareli Police Station, inter alia, alleging that the accused persons named in the FIR, including the present petitioners, had assaulted the father of the informant and inflicted serious injuries on his person. Later on, the accused persons named in the FIR also assaulted the paternal uncle of the informant, namely Monser Ali. Stop. It is also stated in the FIR that the father as well as paternal uncle of the informant are now undergoing treatment in Oval Speciality Hospital. No, uncle is undergoing treatment in Oval Multi-Speciality Hospital, Baihata Chareli, and his father is undergoing treatment in Swagat Hospital. Stop. Learned counsel for the petitioner has submitted that the allegations leveled in the FIR against the present petitioner are not true. It is alleged, it is stated by the learned counsel, it is also submitted by learned counsel for the petitioner that the paternal uncle of petitioner number 1, namely Aminul Chaudhary, was driven out of his house by his wife Amina Chaudhary, and later on the relatives of Amina Chaudhary trespassed into the house of petitioners and assaulted the petitioners, causing injury over the family members of the petitioner's family. And in that regard, one FIR has also been lodged by the who lodged the FIR?
Mother of the petitioner.
By the mother of the FIR, namely Jaeda Begum, which was registered as Baihata Chareli PS case number 183/2024. Stop. Learned counsel for the petitioner has submitted that the petitioners are already detained behind the bars since last 56 days, and considering the period of detention, and the petitioners may be allowed to go on bail. Stop. On the other hand, learned additional public prosecutor has produced the case diary of Baihata Chareli PS case number 184/2024, including the injury report of the victim, namely Islam Ali. Stop. He submits that you are opposing.
Opposing, man.
The additional public prosecutor has opposed the grant of bail to the petitioners on the ground that there are sufficient incriminating materials against the petitioners in the case diary. Stop. Moreover, he also submits that the injury sustained by the victim is grievous in nature, and therefore he opposes the grant of bail. Stop. I have considered the submissions made by learned counsel for both the sides and have perused the material on record. It appears from the case diary that from the materials in therein, it appears from the case diary that there are materials on record to show that it was one Munna Chaudhary who had first assaulted the father of the informant, and later on, after he fell down on ground, the other accused had joined in the assault. Stop. Though there are incriminating materials against how many petitioners? Two. Both the petitioners in the case diary. However, considering the fact that they are detained behind the bars for last 56 days, which is a considerable long period of time, and also as well as considering the progress of investigation, their further detention does not appear to be necessary for fair completion of the investigation in Baheta Chareli PS case number 184/2024 if they cooperate in the investigation. Stop. In view of above, both the above named accused persons are allowed to go on bail of rupees 30,000 each with one surety of like amount, subject to the satisfaction of learned
Subdivisional Judicial Magistrate.
learned SDGM M. Romia with following conditions. Condition number 1 and condition number 2. Now, as the next item number
45.
item number 45. Earlier one was item number 46.
6, ma'am.
Same heard, learned so and so, both the sides. This application under section 482 of BNSS, 2023 has been filed by the petitioners, namely 1, 2, and 3. Naam likhi poti nika. 1, 2, and 3, who are apprehending their arrest in connection with Baheta Chareli PS case number 184/2024 under same sections. Stop. The gist of accusation in this case is same as the first case, earlier case. Oh, Munna Chaudhary is there.
My lord.
There are materials against
My lord.
2 and 3 may be considered.
Atikul and
Azizul is 65 years old.
stop. Learned counsel for the petitioner has submitted that the petitioners are not involved in this. No, the allegations made against the petitioners in the affair are not true. He submits that Agor case to I will show you. Yeah, I will show you in the chamber. Mark at the top, advocacy filing. A, right A, right A. A. एक मुख खुद ही लोगों On perusal of the case diary, it appears that there are sufficient incriminating material against the petitioner number 1, namely Moin Chaudhary alias Munna Chaudhary, as he was the first person who assaulted the father of the informant, namely Islam Ali, with fishing equipments and caused grievous injuries on his person. Stop. Therefore, this court is of considered opinion that this is not a fit case for grant of a favorable order in the section 482 of BNSS. To the petitioner Munna Chaudhary. Stop. As regards other two accused persons, though there are materials to show that they also participated in the assault. However, no specific allegations have been leveled against both of them as to how they assaulted the victim persons. Stop. And stop. Moreover, considering the fact that two of the accused persons who were similarly situated to that of the petitioner number 2 and 3 are already granted bail in BA case number 2529/2024. Stop. Comma. The petitioners, namely Atikul Chaudhary and Atizul Chaudhary, alias Aizul Chaudhary, are directed to appear before the investigating officer of NDPS case number 184/24 within a period of 10 days from the date of this order and cooperate in the investigation. Stop. If they do so within the stipulated period of time, comma, in the event of their arrest in connection with the Bhattacharya PS case number 184/2024, they shall be allowed to go on bail of rupees 30,000 each with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Condition number 1 and 2. With above observation, this anticipated bail application is hereby disposed of. Send back the case diary.
Well, my objection is deeply
And
applies.
mention.
My lord. Deeply. Consent আমার নাই। Petition না দিলে। 48, 47 laws.
May it please the lordship.
47.
My lord, 482 petition, your lordship.
Lordship.
Lordship, in this case, there are two FIRs, your lordship, because the other side, they have also filed a counter class, your lordship. So FIR against me is at face 10, your lordship. The allegation in a nutshell, your lordship.
My lord, before starting my colleague, my lord, here two cities were called for, my lord. Juria 172 of 24 and 173 of 24.
Yes.
But we have received only 172, my lord. Not the 170.
172 relates to your case.
No, the 170 is not related.
172.
No. You have to.
We will require
From other,
173.
the informant side, your lordship.
That will not help us.
But lordship, because on that same date, this affair has been lost, your lordship.
No, perhaps your petition is 172.
Juria PS 172.
TPS দুটা কপি হয়েছে আমার 273 272 একটু ইনফরমেশন ডিসক্রিপশন
আমার against FIR against me is your lordship, PS 172. 172.
172 diary is there.
Here, man.
Okay.
So your lordship, here in this case, allegation in a nutshell, your lordship. They brought an allegation that on the date of incident, your lordship, on 17/6/2024, that we have illegally entered in the premises of the informant, your lordship, with some lethal weapons and inflicted blow on the person of the family members of the informant. But the fact is otherwise, your lordship. The fact remains, your lordship, that we have hired a pond, your lordship, adjacent to the house of the informant, your lordship, for airing fish, your lordship. So accordingly, since you have taken a pond, your lordship, sometime we used to go there, your lordship, to look into the, your lordship, as to the condition of the pond, your lordship. So on the date of incident, when we had visited, your lordship, suddenly we had noticed that the fishing net has been placed, your lordship, on the pond, your lordship, to catch the fish, your lordship. So, your lordship, when we tried to lift or remove the net, your lordship, suddenly the family members of the informant, because they conspired together, your lordship, with some lethal weapons, your lordship, they assaulted us, your lordship, very badly. And that will, to your lordship, case 27 may kindly be looked into, your lordship, as to how, your lordship, the petitioner was being inflicted blow you with sharp weapon, your lordship. Case 27 may kindly be looked into, your lordship. So my respectful submission, prayer, your lordship. So we don't have any main rea, your lordship, no motive at all, your lordship. We just visited the place of occurrence, your lordship, to look into the, your lordship, the fault, your lordship. But we don't have that kind of desire that some scuffle had taken place. That's not, we are not denying the fact, your lordship. But in that under compelling circumstances, because of some private defense, your lordship, incident had occurred, your lordship. But we are not having any armed with lethal weapons. That is totally false.
Medical report and one photographs, my lord. There is also photographs, my lord. I flag my lord.
Photographs are from
So dangerous, my lord.
No, we have also photographs, your lordship, case 27, your lordship. How they have assaulted us very badly, your lordship. And we have proceeded adjacent to the house of the.
My lord, that is
because-
flag, my lord, that is.
Because on many occasions, they used to, your lordship, catch the fish from the pond.
Not the small weapon, my lord.
And the petitioner number 1, your lordship, is seriously, he was undergoing treatment, your lordship. And as of now, he is not in a.
What are the materials against Rezaul Karim and
My lord,
Jahanur Islam?
all of the witnesses, my lord, regarding their involvement, my lord. How they have assaulted, my lord. All of them assaulted, my lord. Jamanur, Rezaul.
No, you go through the case diary,
My lord.
flag specifically. Is there any specific allegation against
My lord.
Rezaul and Jahanur?
Your
If
lordship.
there are allegation, we will not allow the case.
My lord.
Lordship. So
Even
how-
if there is a counter case.
My lord.
So lordship, how the other side will justify the fact, your lordship? How I have been badly assaulted by the case 27 makes.
Then let
They
other
will
city
also
also
be-
come, my lord. Then lordship may consider both of them after going to the both of the city, my lord.
But
After 1 week, my lord.
lordship, because the case is pending for long, your lordship, my respectful
Not pending
submission-
long. Not pending long, yeah.
No, other
Not
city
like-
may not be required. Other city is not against them.
My lord.
Assuming that they have also been assaulted.
My lord.
We have to see that whether there are material against
My
them or not.
My lord.
So you.
Specific
go-
material, my.
Specific
My-
materials,
My
go through the case diary.
That's why, your lordship, I am not denying the fact, your lordship, that something not happened.
But,
Something had happened, your lordship.
but if there
But
are
under-
material,
Lordship.
if there are materials, then this may not be a case for
My lord.
grant of anticipatory bail. Suppose you are not involved.
Lordship, my name is Rezaul Karim, your lordship. Had I been involved, your lordship,
No, let him
because-
see, let him.
My
read
lord.
that. Your case is that
Denial.
they have beaten us,
Yes, your lordship.
we have beaten them,
Hmm.
therefore grant both of them bail. And the factual matrix is correct is because we have taken a pond, your lordship. Because sometimes we used to visit there.
Okay.
That day also we went there, your lordship.
How-
But they have conspired together by
let
family
the-
members, your lordship.
When we,
My lord.
you have to answer this query.
My lord, day
What
after
are-
tomorrow, my lord.
Day after two.
My lord.
After tomorrow.
Let him go through.
My lord.
Heard Mr. A. Devan, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who submits that
Particular, specific.
who-
Specific.
who plays the case diary of case number, who has placed the case diary of Juria PS case number 172/2024 before this court. However, he, learned additional public prosecutor, seeks some time to go through the case diary too before he makes submission as to whether there are incriminating materials, specific incriminating material against the petitioner Rezaul Karim and Jamanur Islam. Stop. The prayer is allowed. Let this case be listed again on
11th, my lord.
11th of September for bail hearing. The case diary may be retained till
Ablaze.
59.
May I please, your lordship?
Yes. Yes.
Well, it's 4% before your lordship. Mainly, well, a delegation against the petition number 1. And 2 is his father. And 3 is the maternal uncle, that is own maternal uncle, father's brother. And 4 is the well, maternal uncle, mother's brother.
What is the allegation?
Allegation, my lord, kindly turn to the affair. That is page, my lord, 12. Here, one lady lost the affair, my lord. Though here mentioned 20 years, in fact, as per my instruction, she is more than 25 years. My lord, next page, page 13 is the affair. Most respectfully beg to state that on 16/7/2024 at about 1 p.m., Iqbal Hussain, that is petition number 1, took me from my house on the pretext of court marriage. Then without doing court marriage, took me out of and told me that tomorrow he will do court marriage and make me stay in Dhaba. There he does not, he does bad work with me, physically captured my naked photos. and
Accused number
published it.
3 and 4 also.
And very unfortunate, 3 and 4, the fact is that, my lord, in Facebook, that informant and the petition number 1, my lord, developed the affair. And she did not disclose that she is a divorcee and she is a minor child, my lord. And when the present petition number 1 came to learn that she is a divorcee and she
Case
has
diary
a-
is there.
My lord, yes, as per 183 statement, my lord, the victim implicated only the.
Except
accused-
two has not been implicated.
Uh,
Abdul Hamid,
here- No. Iqbal Hussain, my lord. Accused number 1 to Iqbal.
Iqbal Hussain,
Against Iqbal materials are others, my lord, only, my lord, মা ভনী মিলি মোক মাৰপিট কৰি খেদি পঠিয়ালে। But against petition number 1, my lord,
so there is no allegation that
specific.
3 and 4 also tried to molest her.
my lord,
মারপিট কৰি খেদি পঠিয়ালে।
voluntarily she came, my lord. And affair also lost after 11 days. Voluntarily she came and forced the petition
Okay,
number 1 to
We
marry.
are allowing for others, not number 1.
1, my lord.
Heard Mr. Ainuddin, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. This application under section 482 of BNSS, 2023 has been filed by the petitioners, namely 1, 2, 3, and 4, who are apprehending their arrest in connection with Moirabari
PS case number 125/2024 under section 318 within bracket 4/316 within bracket 2/127 within bracket 2/64/77/75 of BNS, 2023. The gist of accusation in this case is that on 27/6/2024, the victim lady filed an FIR against the petitioners, before the officer in charge of Juria Police Station, inter alia, alleging that on 16/7/2024, the accused number 1 named in the FIR, namely Iqbal Hussain, took her from her house on pretext of having court marriage with her to a dhaba and subjected her to sexual intercourse and took naked photos of her and threatened her to publish the same in social media. Stop. It is also alleged in the FIR that thereafter the accused number 1 took the victim to the house of other accused persons where the accused number 3 and 4, namely Abdul Mizanur and Sadiqul Islam, also tried to do bad works with her. Stop. Learned counsel for the petitioner has submitted that the victim is a major girl of about 25 years of age. And what else is your submission?
My submission that voluntarily she came
That
to the house of the petition number 1 and forced him to marry. But he was not at home, and other family member, that is petition number 2, 3, 4, they tried to convince and inform
counsel
the
for the
father.
petitioner has also submitted that the victim girl herself came to the house of the petitioner number 2, that is Abdul Hamid, to get married with Iqbal Hussain. And when he was not found in his residence, she lodged a false complaint against the petitioners. Stop. On the other hand, learned additional public prosecutor has produced the case diary of Moirabari PS case number 125/2024 and has submitted that in her statement recorded under section
183 BNSS.
183 BNSS, she has categorically stated that the petitioner number 1, Iqbal Hussain, has subjected her to
Physical relationship and photos were viral in the Facebook.
physical relationship and also made her photographs viral in the social media. Stop. However, against the other accused petitioners,
Other accused person just assaulted her. Only that much. Simple.
she has only implicated that other accused persons have assaulted her. Injury report is there.
No, no.
Only my lord, they try to convince, then you go
Stop.
because
I have considered the submissions made by learned counsel for the petitioners as well as learned additional public prosecutor and has gone through the case diary of Moirabari PS case number 125/2024. Stop. On perusal of the case diary, it appears that there are sufficient incriminating materials against the petitioner number 1, Iqbal Hussain, in the case diary, which does not justify grant of anticipatory bail under section 182 of BNSS to him at this stage. Hence, the prayer for grant of anticipatory bail to petitioner Iqbal Hussain is hereby rejected. However, as regards other three petitioners are concerned, considering the materials in the case diary, this court is of considered opinion that their custodial detention may not be necessary if they otherwise cooperate in the investigation. Stop. In view of above, the above named petitioners, namely Abdul Hamid, number 1, number 2, Mizanul Haq alias Abdul Mizanul, and Sadiqul Islam, are hereby directed to appear before the investigating officer of Moirabari PS case number 125/2024 within a period of 7 days from the date of this order and cooperate in the investigation. Stop. If they do so within the stipulated period of time, in the event of their arrest in connection with Moirabari PS case number 125/2024, the above named accused persons, above named petitioners, they shall be allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Condition number 1 and 2. With above observation, this anticipatory bail application is hereby disclosed of. Send back the case diary.
I'm deeply obliged.
Very please, your lordship. But in this case, my lord, this is an application for, my lord, pre-arrest bail of the accused persons. My lord, 3 accused persons are before your lordship. My lord, here, my lord, something has happened. My lord, due to love
CD
affairs.
is there.
Due to love affairs of the accused number 1 and 2, son of the accused number 1 and 2, with the, my lord, daughter of the informant. My lord, there has been love affair for last 3 years, and which has been admitted by the informant, my lord, in the FIR itself. If your lordship pleases to see the FIR, my lord, FIR is at page 10.
What is the offense?
Offense, my lord, 137, my lord, then 11574, 123. But as per the FIR, my lord, only 1, 2, 3, my lord, is attributable in the case, my lord. 137 subclause 2, my lord, kidnapping.
115.
My lord, 115 voluntarily causing hurt. Then 74, my lord, assault, criminal
123.
force. My lord, 123 is causing hurt by means of poison, etc. Then, my lord, 34 equivalent to, my lord, 35. Now, my lord, there is no material as such, my lord.
Where is the FIR?
My lord, FIR is at page 10, my lord. Allegation is that, my lord, the accused number 1, 2, and 3, my lord, administered some, my lord, kind of poison to the my lord, daughter of the informant, which is absolutely incorrect, my lord. My lord, there is a love affair in between the party, my lord, the son of the accused and the, my lord, daughter.
of the informant. My lord, may I read the FIR? I
No.
beg to inform you that Miss Anjuara Begum
No,
is
no,
my
no.
daughter. She is aged about so
What
and
is
so.
the allegation against the?
My lord, allegation your lordship will find, my lord. So, my lord, in the middle of the middle part of the FIR, my lord, the accused number 3 allowed to leave the accused number 1 and 2. Has your lordship got it, my lord? Middle portion, my lord. My lord, they have, my lord, the informant has admitted that there is a love affair in between the son of the accused number 1 and 2, Ajibul Haq and my daughter. They fled away from home twice, and there were some cases in this regard. Sometimes they are caught.
Yes, Mr. Parashar.
My lord, fact is that as per the 183 VNS statement, my lord, yes, she has love relation with the boy of the petition number 1 and 2, and he called her to
Who
the
is petitioner number 3?
petitioner number 3, one neighboring person.
She was, my lord, there. My lord, what has happened on that particular day, till 7/2000, my lord, 24? The girl, my lord, went to the house of the accused
No, what
person.
is there in the
Yes.
case there?
My lord, the boy called her to their house. She went. Then the Gofur, my lord, father and mother, my lord, father catch her and mother administer her some powdery substance, my lord. And she
What was administered?
some powder
Okay.
powdery substance. My lord, subsequently, she became unconscious. She was taken to a nearby paddy field. Then, my lord, they feel that her condition is deteriorated. My lord, then, when condition deteriorated, they call Nazrul, one nearby person. With the help of Nazrul, she was taken to the house of the informant and thrown out, my lord, nearby the, my lord, boundary wall. Then Nazrul informed the informant that your daughter is lying nearby your wall. Then she was taken to, my lord, first she was taken to one PHC. She was referred to
Initially to his house, then my lord to hospital.
referred to Fakhruddin
That
Ali
night
Ahmed
she was
hospital.
there in their house.
Yes,
My lord,
she was taken to hospital.
on pouring water, she regained, my lord. She was absolutely all right. my
No,
lord.
no, no, not
Thereafter, she was taken to hospital. my
She
lord.
was taken to hospital in Fakhruddin Ali Ahmed hospital, my lord. She was admitted on 19th. She was released on 21. 2 days in hospital. Diagnosis: LS, history of poisoning and physical assault.
Oh.
Result is now little bit improved, release.
So there are materials against 1 and 2.
1 and 2 and 3 nearby person on the
Three is
request of
not
1 and
involved.
2, he has not administered, but on the request of 1 and 2, he took the girl to.
Now, whether you require their
My lord, 1 and 2, my lord.
arrest is necessary if they appear before the IO.
And I'll cooperate, my lord, at any point of, my lord, with any condition, my lord, because
Yes.
fact
Now,
remains,
girl
my
is
lord,
recovered.
girl is
She has
absolutely-
recovered from her ailment also.
Yes,
That
with any condition,
But
any condition. my lord.
a 16 years old girl, my lord, should not be, my lord, this type of.
That is the problem. Now, my lord, they have agreed, both the parties, my lord. They will
that
get
is
their
the
marriage solemnized, my lord, after attaining the, my lord, major age. My lord. That is the, my lord, the
how
subsequent.
Mr. B.K. Sen, learned counsel for the petitioner. Also, Mr. K.K. Parashar, learned additional public prosecutor. This application under section 482 of BNSS Command 2023 has been filed by the petitioners, namely 1, 2, and 3. Apprehending their arrest in connection with Howley PS case number 104/2024 under section 137 within bracket 2/115 within bracket 2 1/74/123/3 within bracket 5 of BNS, 2023. The gist of accusation in this case is that on 21/8/2024, one Afazuddin Ahmed had lodged an FIR before the officer in charge of Pauli Police Station against the present petitioners, inter alia, alleging that the daughter of the informant was having a love affair with the son of the petitioner number 1, and they fled away. Stop. Son of the petitioner number 1. Stop. It is also stated therein that they had fled away from home on 2 occasions. And in this regards, the case were also filed. Stop. It is also, it is alleged in the FIR that the daughter of the petitioner, daughter of the first informant, went to the house of petitioner number 1 and 2, and there she was tortured by petitioner number 1 and 2, and were also administered some poison. Stop. As a result of which she became unconscious, and thereafter the petitioner number 1 and 2 called petitioner number 3, Nazrul, for help, and they thereafter took the daughter of the informant and left her near the boundary wall of the informant. Stop. It is also stated in the FIR that the victim was taken to hospital at Howley, and thereafter to Borpeta Government Hospital, where she was admitted for 3 days and was released on 21/7/2024. Stop. Learned counsel for the petitioner has submitted that the allegations leveled against the petitioners are not true. Stop. He submits that it is apparent from the FIR itself that the daughter of the first informant was having love affair with the son of the petitioner number 1 and 2. And anything else? Any submission? False implication.
My lord, falsely implicated. in
And
the
they
case.
have been falsely, and therefore they have been falsely implicated by the father of the victim girl. Stop. On the other hand, stop. Learned counsel, not on the other hand. Learned counsel for the petitioner has also submitted that the petitioners are ready to cooperate in the investigation, and therefore prays for allowing the petitioners to go on anticipatory bail. Stop. On the other hand, learned additional public prosecutor has produced the case diary of Howley PS case number 104/2024 and has submitted that there are sufficient materials, incriminating materials against petitioner number 1 and 2 of subjecting the victim to torture and also of administering poison to her,
And he,
administering some
some
powdery substance
powdery
to her. Stop.
And she was in hospital for 2 days, 19/7 to 21/7.
He also submits that the victim was hospitalized for 2 days, that is on 19/7/2024 to 20/7/2024. And now she has been recovered. Stop. You are opposing 1 and 2.
My lord, 1 and 2 I am.
Then an additional public prosecutor has opposed the grant of bail to the petitioner number 1 and 2. Stop. I have considered the submissions made by learned counsel for the petitioner as well as learned additional public prosecutor. Stop. It appears from the case diary that there are incriminating materials against petitioner number 1 and 2 in the case diary. However, as the victim girl has been recovered and her statement recorded.
Yes, her statement 183.
And her statement has also been recorded under section 183 of BNSS, this court is of considered opinion that if the petitioners cooperate in the investigation, cooperate with the investigating officer, their custodial interrogation may not be necessary for fair completion of investigation of Howley PS case number 104/2024. Stop. As regards petitioner number 3 is concerned, there are no incriminating materials which justify his custodial detention. Stop. In view of above, all the 3 petitioners named herein before are directed to appear before the investigating officer of Howley PS case number 104/2024 within a period of 7 days from the date of this order and cooperate with the investigating officer in the investigation of the case. Stop. If they do so within the stipulated period of time, in the event of their arrest in connection with Howley PS case number 104/2024, the above named petitioners shall be allowed to go on bail of rupees 30,000 each with 1 surety of like amount, subject to the satisfaction of the arresting authority with following conditions, number 1 and number 2. With above observation, this anticipatory bail application is hereby disposed of. Send back the case date.
Highly obliged here. Highly obliged.
May I please have lordship, my lord? Here in the instant case, my lord, I argued on bail, my lord. Here in the instant case, my lord, I am submitting, my lord, that as per ossification test, my lord, the age of the girl is 21 years, my lord. And my lord, they have produced a certificate, my lord, transfer certificate of the school, which is not admissible under the law, my lord. A transfer certificate cannot be accepted. And this certificate was taken, my lord, after the occurrence of the incident, my lord. And 330 statement, my lord, there on that, there is no, my lord, no question in respect of, my lord, that certificate, my lord. That is the, my lord, in a nutshell, this is a case, my lord. If your lordship may show, your lordship show, my lord.
This is 389.
Yes, my lord.
389.
Yes, my lord. This is, my lord, my humble submission before your lordship is that, my lord. She is above, my lord, 21 years of age as per ossification test, my lord. PW1 has categorically stated. He is the, my lord, medical doctor, my lord.
Then why the court treated her to be a minor?
That wrong has been done by the court, my lord. That is my humble submission before your lordship. Because as per Jugbopoka's judgment, I am directly coming to the judgment, my lord. This judgment is contrary to
You have many judgments.
No, my lord. Today I have only two judgments.
My lord, in this case, my lord, amicus curiae appointed Mr. D.K. Bhattacharya.
One problem is that, my lord, last 1 year, 7 months, I am behind the bar. The age of the boy is, my lord, 24 years, and now the girl, after 6 months, she has married. Admittedly, I prove if it is
No,
possible.
Mr. D.K. Bhattacharya may have to come.
Yes.
We'll fix it. You call him, we'll hear it and dispose of the bail application.
What is it? You see?
Tomorrow,
Yes,
we'll-
madam, tomorrow. Yes, madam.
you inform, you may,
You also may fix at 2. I suspectically call it.
if these are the facts that she,
Yes.
medical doctor has
Yes, madam.
21.
21
21.
days, then at least bail, you
Yes,
may
madam.
have a case for bail.
Yes, madam. And he has posted transfer certificate. That is-
Mr. NNB Chaudhary, learned counsel for the applicant. Also heard Mr. P. Bhattacharya, learned additional public prosecutor, who submits that Mr. D.K. Bhattacharya was appointed as amicus curiae to defend the cause of opposite party number 2. However, he is not present in the court today and therefore requests this matter to be taken up tomorrow in presence of the learned amicus curiae.
At 2, madam.
The prayer is allowed. Let this matter be listed again on 10/9/2024 at 2.
Yes, madam. I shall inform him. Yes, he will appear before the court at 3 p.m.
My lord, as per office code, my lord, 5/9/2024, my lord, service has not been completed, my lord, upon the respondent number 2, my lord.
What will we do? Await.
Yes, service will be awaited, my lord.
Service will be awaited.
Gotcha.
Heard Mr. P.J. Soikia.
LN being able.
Learned. You are Mr. P.J.
LN being able.
Oh, heard Mr. L.N. Dihinia, learned counsel for the petitioner. Also heard Mr. P. Bhattacharya, learned additional public prosecutor. From the office note dated 5/9/2024, it appears that the service report in respect of notices sent to respondent number 2 is still awaited. Respondent number 2 is victim.
Is an informant, my lord.
You take fresh steps.
Lordship. Lordship.
Huh?
Lordship.
The petitioner is directed to take fresh steps for issuance of notice upon respondent number 2 by registered post with AD as well as by usual mode. Within 7 days from the date of this order, returnable after 4 weeks. You are on interim.
Yes, Lordship, there is an interim, my lord. Interim order dated, my lord, 15/9, my lord, 2020.
Stop. The interim order granted earlier shall continue till next day.
Must
Please this matter accordingly.
Wait, please, Your Lordship. This is, and I have filed in a dispose of bail application, my lord. In a similar matter, my lord, in fact, connected to the same FIR one, I was already moved and this honorable court has been pleased to direct the registry to cause an inquiry. If I may just place that order, my lord. One,
In this case also same thing happened.
same FIR, yes. One additional fact in this case is that his bail was made absolute in this case.
Earlier was in interim, no? That in that case interim.
That is interim.
One page was missing, page number 4.
Yes, my lord.
Now what do you want?
My lord, let there be a similar direction because he is the kingpin. The present bail applicant, my lord.
Now here the allegation is,
Well,
your
I have done-
allegation,
I have
your
done-
allegation is that there is a intentional
Manipulation
manipulation
of
of
the
the
FIR,
FIR.
which caused this onward
Yes.
court.
Well, I have gone through that order, my lord, earlier order, my lord. Let the inquiry may be done, my lord. Otherwise, my lord, if genuinely this is done, my lord, then it will be a, my lord, very bad incident for the, serious incident for the.
Yes. For the bar and the bench.
Third, Ms. B.S. Goyal, learned counsel for the petitioner. Also heard Mr. A.K. Parashar, learned additional public prosecutor. This interlocutory application has been filed by the petitioner, namely Shri Sandeep Garodia.
Yes, my lord.
Sandeep Garodia, in connection with AB case number 892/2024, by which the respondent Prakash Agarwal was allowed to go on anticipatory bail. Stop. It is alleged by the, it is submitted by the learned counsel for the applicant that the respondent had deliberately misled the court, this court, by annexing a tempered copy of FIR with his anticipatory bail application, and thereby he had interfered in the course of justice. Course of justice. Stop. Learned counsel for the petitioner applicant has also submitted that by using tampered document willfully in a court proceeding, the respondent has also committed an offense punishable under section 466 of the Indian Penal Code. And thereby he prays for initiation of criminal proceeding against the respondent. She also submitted that in a similar matter, she has brought to the notice of this court. In a similar matter, when she had brought to the notice of this court the fact of using tempered documents by the co-accused, by one of the co-accused, namely Madhurya Das, this court had directed conduct of an inquiry by Registrar Judicial by its order dated 2/9/2024, passed in IA within bracket criminal 779/2024. She submits that as in the instant case, the facts are similar. The registry may be directed to conduct an inquiry in this case also. Stop. To find out as to whether there was an intentional use of tempered document for the purpose of obtaining bail by the respondent, namely Shri Prakash Agarwala and others, and his son. Stop. Learned. On the other hand, learned additional public prosecutor has submitted that since the allegations made in the interlocutory application by the applicant are very serious in nature, and inquiry may be directed in this regard to find out the true facts. Stop. I have considered the submissions made by learned counsel for the petitioner and learned counsel for the applicant as well as learned additional public prosecutor. It appears that in a similar matter, by order dated 2/9/2024, passed in IA within bracket criminal 779/2024, the registrar judicial of this court was directed to conduct an inquiry to find out the veracity of allegations regarding intentional use of tampered document for obtaining use of tampered document in anticipatory bail application. Yeah, no, complete line, complete line. Come on, line to starting with. All of our group. All of our. Maybe application number.
Here 892.
No, no, earlier one. Earlier one. 1152. 1152 / 2024. 1152 / 2024. Stop. As the concern raised by learned counsel for the petitioner in the instant case is similar to that case, Registrar Judicial is directed to include within the purview of his inquiry, which he has initiated in pursuant to the order dated 2/9/2024, passed in IA within bracket criminal 779/2024, comma, the allegations made by the petition applicant in the instant case also. The Registrar Judicial shall verify as to whether the petitioners, whether the respondents, namely, what are the names?
Prakash Agarwala and Ishan Agarwala.
Prakash Agarwala and Ishan Agarwala had intentionally used a tempered FIR in their bail application number,
892.
in their bail application number AB bail application name, AB case number 892/2024 for obtaining anticipatory bail in that case. No. after completion of the inquiry. No, stop before that. While conducting the inquiry, the registrar within bracket judicial may issue notice to the parties and may hear learned counsel for both the sides. Stop. Learned additional public prosecutor is also requested to cooperate with the registrar judicial in the said inquiry. Stop. The registrar judicial shall furnish the inquiry report, furnish a common inquiry report in respect of the earlier inquiry directed by order dated 2/9/2024 as well as by this order. Stop. The registry shall furnish a copy of this order forthwith to the registrar judicial of this court and also place all the relevant materials before him for facilitating the smooth conduct of the inquiry. Let this case be listed again after submission of the inquiry report by the registrar judicial along with the case number, along with the IA, case number IA within bracket criminal 779/2020.
And just one additional fact, my lord, in the other case, this honorable court, while considering whether a notice for cancellation of bail should be given, it did not, that question did not arise there because ultimately it was rejected. But here it was allowed, my lord. And thereafter, after allowing the bill application, my lord, further damage has been caused, but now I don't say anything on that. All the money has been siphoned off after the bail, my lord. Paragraph number 20. In paragraph 12, in the earlier IA.
No, this is this the IA for cancellation of bail?
No.
No, it is in my lord. This I leave it to the court. my
No,
lord.
you can also file an application for cancellation of bail. That
Then
course is
notice-
open for you. If
Yes, notice has to
that
go
we will wait till
till the
the
report
receipt
comes.
of report,
Right, right.
but though you have mentioned,
In the cost title, I have mentioned for review consideration of the orders, proceedings in the AB case number. That I have mentioned though.
but you have to file an appropriate
Since I'm
application.
limited, I can do that, my lord. Can there be an observation, my lord?
No,
There are some limitations, my lord, on that. That is why I was,
okay,
I
this,
will do that, my lord.
then let us wait for the
My lord, my
report
lord,
of the.
my lord. My lord, notice to the parties have been directed. Can there be notice to even others concerned to so that the registry can have a play field that whoever it concerns that because
Others whom,
get a better picture of whatever,
others whom.
maybe from, I do not know, my lord.
No, the registrar judicial is at liberty to
That's correct.
notify whomsoever he wishes,
But in that order, it is mentioned notice to the parties. So
as
parties,
well as counsel,
yes, that also is
as
done.
well as counsel.
My lord, I'm obliged.
Mitase. 52. What is it?
Correction for the procedural, but here, my lord, none has appeared. Session judge
What should we do? We should,
But,
none appears for the applicant for the.
his name is
on
different
call.
in
Let
FIR
this
and
matter be listed again in the next week on the date to be fixed by registry.
Yes.
Ago case. Ago.
First we start, one thing I would like to point out, I've gone through the LCR and LCR only, the order sheet and evidence, that is CD part not received, Case diary part is not available. Here, FIR on 16/12/22, forwarding on 17/12/22, charge sheet on 29/4/23. 6 witnesses in the charge sheet. PW 1 and 2 examined in 23 November and December. Subsequently, what happened? Because of I was on leave and transferred. Because of that, it could not be done. But that only 2 witness examined, others remain, but CD part is not available with the LCR. So to find out the materials against, there are 3 persons. We need that part also, Otherwise, only the statement of 2 persons.
Lordship, this is 633 days till today.
Yes.
And one bail was allowed by this honorable court, so with RRE board. So 2 witnesses was examined and Caesar witness, and both the witnesses did not support the prosecution, and both the witnesses were seasoned witness, stock witness, which is not reliable, and the no specification of allegation against the accused person, petitioners. 2 vehicles were intercepted, and from which vehicle the said contraband were seized, not mentioned anywhere in the FIR or in the forwarding or any record. So, Lordship, the delay, I would like to take the ground of delay, the Chitta Vishwas judgment is there, Shariful Islam, Nitish Adhikari, and Nizam Sheikh. And other than this, 52A.
52A is also violated.
52A is also not complied. For that, I would like to support my argument with Nizam Sheikh versus West Bengal. I will provide you. And one is on and the ground of very
without the case, there is that part.
this is not about the case diary. The section 52 reveals from the Caesar list as well as inventory. Both I have annexed in this petition. So why it is required the CD? In CD, it is not required to reveal the FI 52, section 52, whether it is violated or not. And
when were you arrested? No, for 52A CD would be required. If you are taking.
Arrested on 17/12/22.
Lordship, other than this, I have some more grounds also.
11 and that something kg of ganja.
2 is Caesar witness. And both the NDPS witnesses have told
Mr.
that they are seasoned witness.
Mr. Rahman.
Right, Lordship.
I am just thinking whether to proceed with the hearing now or are you ready?
My lord, without that, my lord, it is difficult. And frankly speaking, my lord, I have got little time to go through, my lord, that. Only I have gone through that time my lord, and several cases there is today. Because of that one of the aspects also, my lord, that part is not there, my lord.
Now whether today we have less time and the
CD is required.
Issue raised would require hearing.
Okay.
Long hearing because.
Make anything very short date.
Considering that 52 is raised the.
Now CDs are sent by the email, so it will not take long time. So make anything given short
that part may be called for.
Case diary is not available.
Not available. Only that only the dates, the order sheets, 2 evidence, and that charge sheet. Only that part.
Okay, heard Mr. M. Rahman in both the cases. Key item, production list
Lordship, both the cases may kindly be taken together.
Both the cases common order নহব, বেলেগ বেলেগ হ'ব।
দুটোতে আপনি আছেন না?
Heard
দুটোতে
Mr.
আপনি
M.
আছেন।
In both the cases, you are appearing.
Lordship.
Heard Mr. M. Rahman, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. Who submits that considering the nature of grounds taken by the petitioner in his bail application, perusal of the scanned copy of the case diary of which PS case number is
Lambdin PS case number 201/22.
Lambdin PS case number 201/22 in
20.
connection with special NDPS case number 42/23 presently pending before the court of which court it is pending?
Court of
Special judge, Hojai.
special judge.
Special Judge Hojai
Hojai.
would be necessary. Hence, call for the scanned copy of the aforesaid case diary. Registry to take steps for requisitioning the aforesaid case diary. Let this case be listed again on when. It will come by mail.
Yes, can you next?
বৃহস্পতিবার, Thursday, 12 তারিখ।
মনে করছে না?
Lordship, may kindly be fixed on Thursday.
Or 17, 12 or 17.
Thursday means
Thursday means 12.
12 or
30.
17.
17 would be good. On 17/9/2000.
Okay.
Note that case. Finish.